Yes. Yes.
To mention for inclusion of motion,
Motion, please.
Similar prayer.
Motions, please. And for the grateful for
My
that.
lord, may I be permitted to mention a review application, my lord, arising out of a civil revisional application. Lordship had directed in that order that the learned trial court will complete the hearing and dispose it off in 3 months. That time expires on 1st of December, which is the last day fixed, my lord. If it is not taken up before that, my review, it will become infructuous, lordship. And it was based on the submissions, erroneous submissions made by the petitioner. I was the opposite party, could not appear because I could not come to court that day, my lord. So they made certain submissions before, my lord, based on which the order was passed on that ground, my lord.
The petitioner.
My lord, I shall serve notice, lordship. If my lord, of date may be fixed, lordship.
Please hand over the slip.
My lord, deeply obliged.
My lord, may I be permitted to mention CO 3617 of 2025, which has already been disposed of on 26/9/2025. My lord, the case status is showing, my lord, the order has not yet been uploaded. Obligement.
So please hand over the slip.
Lordship, this is my intervention application. The writ petitioners have suppressed material facts.
Hand over the slip. Yes.
Item number 9192
Nine
in the monthly list.
Yes.
That is a contempt matter. My junior has several occasions mentioned this matter. On Monday, my lord has requested him to come on after 2 days. Difficulties, my lord, octogenarian, every day.
91, 92.
91,
contempt.
92.
Yes. I will fix a date for contempt matters in the next week.
So that we can, at
Yes.
least, my lord, even admission has not taken place.
All right. Yes. Call the next one. Number 1. Yes. Correction, please.
In place of CO, it would be WPL. Minor.
That hangover is continuing of the previous determination. Ashok.
I think 3 was similar. CO.
CO. What was same? What is CO? Yes, next.
Order dated 10th.
Yes, next. It okay, same.
আচ্ছা
It okay. Next, same order. Yes, next. Five was same.
My lord, wrongly appearing, my lord.
No. I think there is a typographical mistake.
The WPA number is correct. It's under extension of interim order.
Year is wrong, my lord. That's why
And
the
the
wrong
cost
cost title
title
has
is wrong.
Oh, cost title has.
yes. Madam,
Oh, cost.
I may come back at 12, my lord.
ফাইল কি অরিজিনাল ফাইল এসছে?
না, অরিজিনাল ফাইল এসছে।
তাহলে আবার
না,
বসে
স্টেট
থেকে।
নেই তো।
এই তো।
অন্য
State
ফাইল
আছে।
এসছে এখন।
কলেজ সার্ভিস কমিশন।
ও না, এটা মামলাটা, এই মামলা ডিসপোজ হয়ে গেছে। ও এটা অরিজিনাল
এসে।
যে মামলাটা, সেই
এটার
মামলাটা
জন্য অন্য কষ্ট। Let it appear tomorrow under the correct cost title. I will pass orders tomorrow.
Can be taken as today, madam. Today.
Okay, why?
Today I have some difficulty in today in the first term, madam. If it is possible, madam. Otherwise, I will certainly.
All right, let us supplementary করে দিন। Yes.
But directed on the other day, my lord, to bring the instruction on behalf of the.
Yes, where are they?
বন্ধ করো।
Yes, madam, you are representing whom?
My lord, I'm representing Airport Authority. Airport Authority of India.
Yes.
My senior is on his way.
Pass over next. Yes.
My lord, item number 7, Learned Senior Counsel Mr. Shoktinath Mukherjee sir is appearing virtually, my lord.
This is that matter my lord was hearing yesterday, madam.
My lord, I am praying, my lord, an opportunity to file an affidavit in opposition.
Affidavit in opposition, Mr. Mukherjee is all right, but do you have any permission from the authorities?
I have heard that documents have not yet come to me. They have a license from the government. They have got a permission from the municipal corporation. So far as no specific permission from the government, the government has now issued a circular that cafe, restaurant are permissible in residential area subject to certain conditions.
No, but whether you have got the permission, where is the permission?
No, possibly no permission. I can't tell you, Lordship.
Mr. Mukherjee, unless and until the permission is granted, you
My
cannot
point
be
will be-
permitted to use it for a purpose other than which it was leased out.
My lord, my submission will be that's a clause in the lease deed. Lessor has not taken any debit. May. Lease deed permission, suppose I have not taken. A third person cannot enforce it. Lessor can always waive it. Public
Yes, but,
interest.
But you are running a hookah bar in that property without permission.
Not hookah, I don't know. I am running a
Yes,
cafe.
there are evidences which has been produced along with the writ petition.
I beg to
Statements are there and inspection was carried out by the authorities. They
My
have
lord,
also said.
I'll satisfy Lordship by an affidavit.
Yes,
Hookah bar
but you cannot use it for those purposes.
I'm using it for a long time.
Maybe, but unless and until any permission is granted for the time.
Permission under the lease deed, not under the statute.
No, under the statute, this hookah bar you cannot run that without permission. Where is the state?
Time for the state response led by Mr.
Where is your,
Vivekanand. Lordship,
yes.
I have the soft copy
What
and
steps
one.
have you taken?
Lordship, we have inspected yesterday, Lordship.
My lord, kindly give me a
Printout,
copy.
Lordship. I haven't received the hard copy yet, Lordship. It's just a printout.
क्या है भाई ये thing?
Lordship, on point 8, we have received one online
Please
application.
give me a minute.
Lordship.
भाई আমাদের copy দিন।
So what steps have you taken?
Lordship, yesterday only we inspected the place, Lordship. We will start taking the steps, Lordship.
How much time it will take to take steps?
Lordship.
Because the complaint was lodged sometimes in September 2025. At that time, you took the plea of festive season. Now festive season is over, madam. Now it was taken up on 12th of November.
Yes,
You said that yes, you will take steps. Today also you are saying that you will take steps.
They have went to the place, Lordship, yesterday. Lordship, they will start. Lordship, give some time. They will do the action.
How much time I'm asking you to take steps? How much time it
They
takes?
start taking.
The festive season is not yet over. Up to
Yes.
Saraswati Puja.
Mr. Mukherjee, that cannot be a ground that if the festive season is continuing,
I am saying
the authorities
the
will sit tight.
Lordship, the department was closed, Lordship. Not because of the festival, the department was closed.
Department was closed from 20th of September till yesterday.
Till date that, Lordship, on certain time was there. It was not.
Don't take all this, please.
Lordship.
Don't take all this, please. Authorities have to act.
Lordship, give us some time. We will do it as
Yes.
My lord, let me have a copy of the report have submitted to Lordship.
Lordship,
Yes.
I will give the soft copy. I haven't get the hard copy yet, Lordship.
Right,
It's
I'm
coming
keeping
on.
it tomorrow. Please file the report.
Lordship, it's a report only, but I have given you the printout because I have received the soft copy, Lordship. I have given you one printout, Lordship, from there, but the main hard copy, the signed copy is coming today only. So if your Lordship permit, I will give the report in the main today only in the file, Lordship. The original signed copy, Lordship.
Lord, may I only just take 1 minute? Lordship will kindly consider closing it down at least as an interim measure to not let them pray G. Lordship will kindly consider that. What happens is, I have 70-year-old parents who live there, and the whole day there is the smell of hookah. I have a 4-year-old son. Pray G, kindly consider, my lord. Ex-facie without license, without any permission.
I have got the license. I'm told I have got the license. I have got the.
Yes, where are those licenses?
My
Who
lord,
is the-
I wanted.
Yes, please show the licenses. Madam, please show the licenses.
Hey, fire
You
license.
present on the last occasion On the last occasion, you said that on the very last day.
এই লাইসেন্স আর পারমিশনটা মিউনিসিপাল কর্পোরেশন জজ সাহেবকে দেখাতো কে আছে আমাদের
Yes, yes, sir.
Please produce the permission which you have obtained for
fire
running.
license. I've got the fire license and the certificate of enlistment.
That's probably a fire license.
Government is permitted it.
It is a requirement of conversion of residential property to commercial.
দেখিয়েছো এটা?
না এটা দেখায়নি, but I've shown an RTI reply by which the state has said that there is no conversion. That's what it does.
Can I have a look at it?
अच्छा, copy नहीं है, sir.
Madam, I'm keeping it tomorrow.
Lordship,
Please file a report as to what steps you have taken.
be on Monday.
Not starting.
Lordship, can it be on Monday, Lordship?
No, no, no.
My lord, I was assisting Mr. Mukherjee. My lord, tomorrow, my lord, I have some difficult demand. Maybe my lord come, my lord, on Tuesday. If
No,
my
no,
lord,
no.
my lord kindly allows us, my lord, this much of time. Tomorrow, my lord, I am not there. I will not be able, my lord, to be there in court.
Let them show something of how much time it takes the
My lord, kindly
authorities
allow
to
us, my
act.
lord, to come back on Tuesday.
See that first, Mr.
Kindly, my lord,
Banerjee.
allow us to come back on Tuesday. My lord,
Yes, yes, you may come back,
my lord, the
Mr.
restaurant is
Banerjee. Let first, the court has to see how much time is necessary
my lord,
to
will show
activate
everything. My lord,
an
will produce
authority.
everything before the.
That is to
My
be
lord, will
first
produce
seen, Mr.
everything before
Banerjee.
the honorable court. My lord, this business is being run,
yes.
my lord, for a long time. My lord, let us,
Maybe,
my lord, come back, my
but
lord,
not without
2-3
permission.
days after
Mr.
only.
Banerjee, are you suggesting that without permission you can run anything in a property?
Well, permission under the lease. Kindly do not forget it.
Yes, permission under the lease, but not from the authorities.
The permission is not from
Permission
him.
under the lease is only for
Not under the
residential.
statute.
For residential.
The notification
That
that
is for
comes out
Government has
residential.
done,
mandatory
government has done
permission
it.
is not there, and a hookah bar runs from September.
Ashun.
Lordship, kindly on Monday, Lordship. Yes, tomorrow I have some difficulty, Lordship. Kindly.
The learned advocate appearing for the state submits that some time may be, some further time may be granted to allow the authorities to take steps. First up, let a report in the form of an affidavit be filed by tomorrow, bole kalke date, indicating
Lordship,
the
kindly.
steps taken by the authorities pursuant to the complaint lodged by the petitioner on
8th of October 2025.
October 8, 2025. Full stop. Mr. Mukherjee, learned senior advocate representing the private respondent, submits that the private respondents have the right to use the property for non-residential purposes pursuant to the lease deed dated October 13, 1976.
No, they have come through by way of
Where
an
is their lease
assignment.
deed?
1976, Lordship.
13th of October 1996 is the parent lease.
Yes, no, their lease, Mr. Mukherjee submits that pursuant to.
This
Yes,
is the
where
one.
is your lease?
This is the one, 13th October.
Mr. Mukherjee, you are referring to the 13th of October 1976 lease.
Yes, yes.
I'm not very sure. I'm a lessee, that is admitted.
There's no change of use.
Mr.
Yes.
Banerjee, that is the date.
Well, that is the date so far as I know, my lord. We need to see it once. My lord, we have been briefed, my lord, very recently. My
Banerjee,
lord, I
you
need
have
to
got the
see it with
copy
my
of
learned
the.
senior.
You have got the
My
copy
lord,
of the lease
76
petition.
leave date, my lord, that's the only
That
lease
is the
date
date,
that I have
sir.
come
Date
across so far.
date likhte habe na.
This is the one.
Pursuant to a lease deed.
Lordship can record the date, 13th October 1976.
That's
At
the only
page
lease deed I
39.
have so
No,
far
that-
come
that
across. My
has-
lord,
They
I
have
have so
come
far
by way
come
of an
across.
assignment. The terms have not changed.
All right. I'm not mentioning the date
Very
by
good.
virtue of a lease deed. First up, Mr. Mukherjee submits that the private respondents are using the property strictly in terms of the terms and conditions, strictly in accordance with the terms and conditions as mentioned in the lease deed.
I have not said so, my lord. I have said I'm using it under the lease. If there's a violation, there's a violation of the lease. A third person cannot complain if the lessor does not take steps under the
Oh,
lease.
ঠিক আছে তো কি বললাম মিস্টার মুখার্জি না 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 ওটা কেটে দিয়ে Mr. Mukherjee submits that the petitioners cannot raise an objection as to the alleged violation of any term. alleged violation of any
Of the-
terms and conditions of the lease deed.
Yes.
Of the lease deed. Yes, of the lease deed. Full stop. A report has been filed by the land manager Bidhan Nagar dated November 12, 2025. Full stop. In the said report, it has been specifically stated that no formal permission for non-residential activities in the residential building has been issued in favor of any person till date. Full stop. The report further states that there is no provision for running hookah bar. Full stop. In the writ petition as well as in the complaint lodged by the petitioner before the concerned authority, it has been specifically alleged that the private respondents are running a hookah bar from the ground floor.
Yes.
From the ground floor of the premises in question. Full stop. List this matter. List this matter tomorrow under the
I have
heading.
not even served the report. Report has to be served upon me.
Yes, I'm directing them to serve a copy of the report. কি বললাম? Under the heading for orders and প্রথমে report to be filed stating what steps for filing the report by the land manager is which respondent?
Respondent number 3, Lordship.
By the third respondent.
Lordship.
As
Milord,
directed
kindly
there.
indulge us this much. Milord, kindly allow us to come back on Tuesday. Milord, nothing will happen in 2-3 days. Milord, let us, Milord, sit together.
Mr. Banerjee, let me first see how much time the authorities take to act. Let me first see, then I will consider your prayer.
I'm so
because,
grateful.
They have to be activated.
I am
Wait.
half dead.
Be activated
Mr.
first.
Banerjee,
Kindly on Monday.
Mr. Mukherjee,
I'm
Sir,
saying
এরম বলবেন না, স্যার,
half
এরম
dead.
বলবেন না।
Mr.
Mr. Banerjee, Mr.
Kindly
Mukherjee
এরম
is
বলবেন
submitting
না।
something.
Somewhere.
Mr. Banerjee, Mr. Mukherjee is submitting something. Please allow Mr. Mukherjee to make his submission. Yes, Mr. Mukherjee.
Milord, I'll be able to have the assistance of Mr. Banerjee. Mr. Banerjee is not available. Kindly give him a day or two.
No, Tuesday I will be keeping, let them file the report only.
Right.
Let them file the report tomorrow. I will consider, I will keep it on another day.
Lordship, kindly Monday,
Today's
Lordship.
report can be circulated, not
The learned advocate for the third respondent is directed to circulate the report dated 12/11/2025 filed in court today to the contesting parties.
Lordship, kindly on Monday, Lordship, kindly.
No,
Then
please
Lordship,
start acting. Please
we will,
tell them.
Then Lordship, there is a report.
Otherwise, court knows how to activate the respondents.
We will, Lordship, and then the Lordship, there is a report.
That is why I gave you chance till today.
Lordship,
Now it seems that you are taking these orders very lightly.
Lordship, they have went for the inspection. Lordship.
Please show what steps have you taken. If this is the allegation, what steps have you taken? Please state it in black and white. What are the steps you have taken? Not we are going to take steps. That much I want to see.
Then Lordship, it's report.
That liberty, for that I have kept it today. But it appears that unless a strict order is passed, you will not act. That is why I want to see how much time it takes for the authorities to act.
Lordship.
For that I am keeping tomorrow. Yes, call the next
Lordship,
matter.
It's a report in the form of affidavit. Can it be report, Lordship?
No, report in the form of an affidavit. I can keep it at 2 p.m. 2 p.m. রেখে দিন কালকে ওটা. For us 2 p.m. in the first half you can file the affidavit. Oh, at 1 p.m. At 1 p.m. Yes, call the next matter.
grateful.
Deeply obliged, my lord.
এই রিপোর্টটা টেকে নাও.
Appear for the petitioner.
Grateful, Your Worship.
Thank you, Mr. Mukherjee. Yes.
I appear for the petitioner. I appear for the petitioner, my lord. The petitioner happens to be legal heir of one Jotin Bihari Rai Chaudhuri, who had obtained a land under the scheme of refugee rehabilitation scheme in Bijoygad area, my lord. Now, I have made a representation to the deputy controller of the concerned department at page 33 for recording my name, since the Jatin Bihari Rai Chaudhary died, that initially that kindly comes to at page 33, my lord. Page 33.
Yes.
Now, my lord, this was not initially moved. Subsequently, hearing is initiated.
So this was for freehold deed.
Yes, freehold deed.
Now deed has been executed.
Yes.
No,
No,
it has
no.
been executed.
This has not been executed, my lord.
Yes.
It was recorded in the name of Jatin Bihari Rai Chaudhary.
Show me where is that document? Where is that document that was recorded in the name of Jatin Bihari?
No, it was recorded in the name of Minali Rai Chaudhary, the mother of Jatin Bihari Rai Chaudhary.
Where is that?
May I show the record, my lord? Page 71, my lord.
71.
71 corporation record. And she is, my lord, the owner, Srimati Minalini Rai Chaudhary. Third column, my lord.
Yes.
Now, after Minalini Rai Chaudhary, Jatin Bihari Rai Chaudhary, from Jatin Bihari Rai Chaudhary, I am claiming the property. I don't have any other property anywhere else, my lord. I filed a representation before the controller. Now, controller takes up the hearing, my lord.
Yes.
During
Order has been passed.
no order has been passed. My kindly sees page 72. During the course of hearing,
Page 72, yes.
during the course of hearing, with reference to the memo number, so you are not living at so and so since long and submitted a NOC in favor of your brothers regularizing your share by executing an affidavit before the first class judicial magistrate so and so. It is also evident that you are otherwise rehabilitated in your matrimonial house as a being legal heir of the refugee. As a policy, the government provides only one-time rehabilitation benefit to a person. But this conclusion, the authority comes to a portion. These property where I am presently here, the matrimony.
Bhattacharyji, this is in the form of a show cause notice.
Kindly just, my lord.
In the form of a show cause notice, you
Is
give
a-
a
is a-
reply
is a-
to this.
No, I have
Oh, you
given
have
a
given a
reply. I
reply.
have given reply. The authority comes to a predetermined way. Whether the matrimonial home where I am residing, it's the name of my father-in-law. After father-in-law, my husband is still living, who is the present owner. So I cannot become the legal. The authority comes to a policy that I will be the predetermined. Now, my lord, kindly sees my representation to that effect, my lord, 23 onwards.
No, what happened on 4th of November?
Well, I have prayed adjournment.
Why?
I have prayed adjournment, my lord.
Appear, let them
Yes.
pass an order.
But I kindly sees, my lord, the authority is a prejudged way considering. Kindly comes to page 73 onwards. I have made a detailed representation. The other legal heir have a property in own. It is as per the scheme, he cannot be entitled. Whereas I don't have a property. Now the concerned authority, without considering all these aspects, proceed. Kindly comes to the
state, madam.
Who are you?
I'm for the state.
Kindly
On behalf of the department, madam. My submission before your lordship, although have not got the full instruction.
Who is any private respondent?
Yes, my lord, I am appearing.
Oh, you are for the private respondent?
Yes,
It's
my
a
lord.
premature application, madam. Madam, my learned friend's client is apprehending
Absolutely.
that the order will go against her. But the basis is this, ultimately, employing another RR property.
How do you justify your observation at paragraph 3 of the third paragraph? There is no paragraph number at page 72.
Yes, on the basis of.
You have expressed your opinion.
Yes, on the basis of a no objection.
You have,
In
so if you say
2013
that this is your ultimate order, then I will consider that. Or you can.
That I cannot say, my lord. Immediately here and now, without getting instruction, but I cannot say this is the final observation. But
So
this is,
you
this has
decide the
come-
matter without being swayed by this observation in paragraph 3 of the.
on the basis of the records available to the.
Yes. Records.
But nobody can transfer a property on the basis of the affidavit. Here the authority
Mr. Bhattacharyji, that decision they
there
have
is a
not
scheme,
taken.
my lord.
So
Not that-
it's
But
this
the private-
observation, Mr. Bhattacharyji, this observation is troubling you.
Yes.
So I'm saying that this is only a prima facie finding.
But the
This
other
is only a prima facie finding, and they shall pass an order without being swayed by
Yes.
this finding. Let them take a
But
final
Mr.
decision.
This is not a private property. This is a property under the RR and R scheme.
Yes, yes.
Therefore, there is a scheme, there is a policy, there is a my lord, procedure. Though if somebody married and ultimately she is enjoying two properties, two RR properties, this cannot be done.
Mr. Dotto, there are two ways. One thing, yes, if you say yes, this is the final decision, then it's one thing. But you have asked them to explain, and you have said it is also evident that you have otherwise
Therefore,
provide
that's why
only one time. So
let them
without
explain.
yes, they have given a
I
reply.
have given a specific reply.
They have
I-
given a reply. Please,
Say this is a
Well,
yes, that is why. Please consider this, pass a
Yes, of
reasoned
course,
order.
yes, of course.
But
Because his
this
prayer is this to remove
only
this
this
officer.
paragraph should not be the basis of your final.
Yes. Well, kindly makes the observation to that effect.
But
Yes.
his prayer, my lord, kindly consider his prayer. He is the apprehending that this officer will not justice to him. That's why the
Obviously,
prayer
my-
is to remove that officer. How can it be?
Where is that?
First prayer of the writ petition.
That is not their contention, my lord.
They apprehend the order will
But I have
not
made specific observation that about the prior respondent because they have a owning land property. As per the refugee rehabilitation manual, a person who is having a property cannot.
Under
All those things make submissions, they will pass an order.
under the RR and R scheme, if she is entitled, she will get his shares.
Yes, what is
Not-
the submission? You attended, you have been also asked to.
No,
attend
no,
this?
no.
Yes, I was also asked to attend the hearing, my lord.
Yes.
I was there, my lord. Last occasion, they
Who are
shot
you?
for. I am the brother, my lord. Basically,
Brother of
brother of the petitioner, my lord.
She or the other sister.
She is staying somewhere else, having another RR plot, my lord.
And
That is
Let
the whole
them
difficulty,
prove.
my lord.
Well, let them prove the brother is having a property there. As per the refugee rehabilitation manual, a person cannot.
so he is also being given an opportunity of hearing.
As I find, they are saying the from
But
not
where,
from
where,
this-
where
Yes,
I have made
they
a
are there,
specific. 1 minute.
They are also called us also.
I have given a
So
specific.
I'm directing them to dispose of this,
and-
considering your reply, giving both of you an opportunity of hearing to pass a reasoned order without being swayed by the findings.
and a detailed hearing
on
be
the
given
basis
to
of
us.
the record,
On the basis of the record, my lord.
And kindly
Has to be on the basis of the record.
My lord, absolutely.
Has to be as well.
ঠিক আছে ঠিক আছে হোক না
The
এটা উড়িয়ে দিন।
Mr. Bhattacharjee, where are those facts? Who was the original allottee? Where have you stated? Who was the original allottee?
Well, Mrinalini
Raito-
is 70
Rai Chaudhary was the original.
Yes.
See, my lord.
original 71.
Reena Lee.
Then
Rina-
from
Reena Lee Roy Chaudhary.
so it has
Rina
been
Nini
said,
Rai-
Rina Nini,
Page 71.
paragraph 6.
Mrinalini.
Now from whom? Who got it?
Jotin. From Mrinalini. But after Mrinalini's allotment, no transfer took place.
Mrinalini's son is Jotin.
Yes.
But Mrinalini had two sons,
Yes.
Roy and Jotin Roy.
Jotin and
Pulin Roy and Jotin Roy. Left behind two sons. Pulin Roy,
where Pulin Roy. Yes.
Pulin Roy deceased,
Pulin Roy and Jotin Roy are the two sons of.
Mrinalini.
Yes. Then
Thereafter,
Pulin
deceased.
died.
Pulin died.
Yes.
Jotin is Jotin is surviving. Thereafter, the petitioner and the
So
private
Pulin died without any heirs.
Pulin died without
Without-
heirs.
Now Jotin,
Thereafter, Jotin's legal heir, Jotin and
petitioner and the private respondent are the heirs of
sons
Well,
Jotin.
Jotin.
Well,
Jotin, madam.
I am told, my lord, Purin's legal are there, but one of the legal is still living. They have been not called in the hearing also.
That is, you are not espousing
I am
the
no.
cause of.
No.
In any event, occupy any land other than what is allotted to you under
That's
clause
the
2 and
scheme.
3.
That's the
Yes,
scheme.
But they are also barred for
Getting
the.
only one property.
But
Yes,
they are,
madam.
but they are also barred.
Respectful, madam.
But they are also barred to that effect.
If it is
Only one thing, my lord. The affidavit service ready is entered, but not affirmed. I just
Please affirm it and file. লিখে দিই এলে তারপর কিন্তু ওটা নাহলে কেটে দেবেন।
affidavit service টা দিয়ে যাচ্ছে এক্ষুনি। হ্যাঁ হ্যাঁ, অ্যাফার্ম করে দিয়ে দিচ্ছি।
না দেখি এতদিন মামলা শুনে গেলাম। না দেখি এতদিন মামলা শুনে
বলছে স্যার
যা পাচ্ছিস
কাটি করো না।
Only not this week because my lord, copy has been served upon the private respondent. But
copy
has been served upon the private respondent by speed post. My lord, the track record does not show the delivery, whether it is delivery or not. It is not showed, my lord. And therefore, my lord, I am saying only not this week.
Yes, what is your instruction?
My lord, I have not received. Only this morning I have received this brief, my lord. I am also praying for some time to file my instruction.
আসুন।
And I have already received the instructions. Though I have received,
sir, give me 10 din.
The matter may be disposed of, my lord.
Yes, their instruction.
My lord.
What is the allegation? Encroachment.
My lord.
PWD road.
My lord, yes.
But upon receipt of the writ application, my lord, the assistant engineer PWD has approached the concerned BLR, my lord, to cause an inspection and demarcate, my lord, and thereafter we will take steps accordingly, my lord. But this is the communication. So, my lord, your lordship so desires, my lord, can dispose of the application, my lord, by directing the BLO, my lord, to dispose of this representation and the engineer PWD to act accordingly.
Only one thing, the private respondents have not yet been
My lord,
served.
but my lord, if the land is inspected and demarcated, none of the parties will be, my lord, prejudiced. And my lord, it will be done in the presence of all the parties, and my lord, later opportunity of hearing may also be offered.
At the time of
inspection.
Inspection opportunity, where is the provision, sir?
No, my lord, in the presence of all the parties.
That you can do, but not
Yeah, my lord,
hearing.
unofficially, the hearing continues.
Hearing at the time of inspection, what hearing?
My lord,
only the Amins and
presence of the
surveyors will
parties.
go there.
My lord, inspection in the presence of the parties.
Kindly make it on the 18th.
All right. The learned advocate appealing for the same order আগেরটাই করে
No, I am for the petitioner.
Shobhaji Mukherjee is appearing for the state.
You're for the state.
Rashid. Shobhaji Mukherjee is appearing for the state.
There is no private
Who is
respondent.
My
appearing?
senior, Rashid. My senior Shobhaji Mukherjee.
Yes.
This
Yes.
is a video service, my lord. My lord, the matter relates to me, lord.
Any
payment-
private party?
No, private.
No private
No
party.
private party.
What do you want?
My lord, compensation, my lord. The land has been acquired. Then land has been used
Under what proceedings?
under, my lord, LA proceeding, my lord.
LA proceedings.
1948. my lord.
1948.
My lord.
Act 2 of 48.
Act 2 of 48.
It proceeded up to the acquisition stage, or it was at the
only
requisition stage?
4-1 proceedings was started. 4-1 proceeding notice was started. Thereafter, my lord, land has been acquired and then used, but my lord, no compensation has been paid.
No award has been declared.
Had been declared till date. My lord,
It was converted to 9(3)(b. No.
no. My lord, I made earlier. This is second round of
This is
litigation.
second
my
round.
My lord.
What happened in the first round?
First round, my lord, the honorable court, my lord, directed the authority to consider the matter. My lord, the order, my lord, is at page, my lord, 11%, my lord, page 53, 54. Thereafter, the passed an order.
Direct purchase policy.
No, my lord, they have, my lord, proposed. My lord, I am not willing to the same. My lord, kindly see, my lord, page 56. They are order.
Page 56.
My lord. Subsequently, they proposed, my lord. But in that order, there is no, my lord, 56, my lord. First, my lord, the relevant for 57, my lord. Order 8th of May 2018. 57. Relevant order, my lord. On verification of records, the LA case number 255 of 1970-76, it transferred that land in question, that is RS plot number such and such, 11 decimals and 1 decimal, that is totaling 29 decimals, including other lands, having been area of 12 acre 82 decimals, was requisitioned under 3(1) of the Westmoreland Land Acquisition Act, Act 2, for construction of Sobang Mahar Odia, as per proposal received from Preventive Engineer, Road Planning Planning Circle, Calcutta, Alipur, 27, White Member such and such. The plots of land have been taken over and delivered over to the RV regarding body on 22nd of February 1978, including other lands for total area of 12 acres 65 decimals. Notification of 401A of the said act has not been published in the Calcutta Gazette for acquisition of the said land. So no award has been prepared and payment has not been made to the petitioner for his land so requisitioned at that time. The requiring body has also not placed fund at the time for the land so requisitioned, except rupees such and such for the construction structure of the lying upon the land. The LA proceeding under LA case number under such and such should lapsed as the said act became inoperative after 1st of April 1997 due to repeal. After repeal of the Act 2 1948 for disposal of the such lapsed acts, an amended provision was inserted in section 9(3) of the Act 1 of 1894 for its application in West Bengal state only by enacting amendment of new legislation of West Bengal Land Acquisition Act, Amendment Act 1997, there is Amendment Act 1999, which is known as 9(3) for those cases where notice under 4(1)A of Act 2 of 1948 was not published, but possession of the land was taken over under the said Act, section 9(3)(b), where possession was taken under Act 2 of 1948 and notice under section 4(1)A of the said Act was published in the Calcutta Gazette. Subsequently, the said LA Amendment Act 1997 was also revalidated. The West Bengal Land Acquisition Laws Amendment and Validation.
Yes, what do you say?
As per the instruction of my senior, filing report is required, Lordship, from the concerned respondent authorities, particularly from respondent number 4.
Particularly from the respondent number 4. Who is the respondent number 4?
Lordship, the land acquisition collector of Paschim Mednipur.
Land acquisition collector 4 or 5 would be the appropriate authority.
4, 5 both, Lordship. 4, 5
both.
And more
Who is
important,
the requiring body?
With the PWD, level of 6.
PWD has placed the funds.
No.
Lordship, for that reason, report is
No,
needed.
why report? So you have written to the chairperson
my lord, we are disputing that.
What
my lord.
happened to this? This
I'm-
was in 2020.
2020, Lordship. Lordship, the instruction is that report is required, whether the amount has been disbursed or not, whether the construction is over this particular land or not. So for that,
Madam, have you gone through these papers? There is no dispute that you have utilized. You have utilized. There is also no dispute that you have not passed any order. Those facts, there is no dispute. Only what is the estimate? As per the direct purchase policy, you cannot enforce that against the wishes of the petitioner. That you cannot do.
okay, Lordship.
It is only if the petitioner is agreeable, yes.
My lord,
As
we are
per
not.
the direct land purchase policy, you can pay, or you have to initiate a proceedings.
Then, Lordship, the total estimate, Lordship, need to be filed. Lordship.
Yes, Mr. Mukhopadhyay, you are appearing in this.
No, no, Lordship. Supratim, Lordship, Advocate Supratim Dhar is appearing.
Supratim. I thought the Supratim. Where is Mr. Dhar?
He's court number 16. He's a court number 16. 16.
Ask him to come.
Your Lordship.
Pass over. Yes.
Same matter, my lord. My lord.
Same.
Same. Almost same, my lord.
Who is appearing for the state?
Same plot.
Pass over. Next.
13, my lord, I'm for the petitioner, my lord.
Yes.
Lord, I have challenged an order of BLRO, my lord. I know, my lord, after L. Chandrakumar, my lord, cannot interfere with the
Then why have you
order of
filed?
BLRO. But, my lord, kindly seize the order for once, my lord. My lord, this order, my lord, suffers from, my lord, palpable error, my lord. My lord, kindly seize page 127.
127.
My
127 is the Vakalatnama. 126 is the last page in your
my lord, annexure P6, my lord, there might be some.
This is 126.
126. 126, my lord. My lord, may I just read out to your lordship, my lord?
Yes.
With reference to the above subject matter, this is to inform you that the Khatiyan number 271 of jail number 163, which you applied for change of Shebait name in Devottar Khatiyan in the name of Shri Shri Sridhar Thakur in Khatiyan, there is one Shebait whose name is Bijoy Mukhopadhyay. He is the predecessor in interest of my client. Your application for addition of Shebait name is not permissible as the custodian of Devottar property is district magistrate. To change anything in Devottar property, you must first take permission from the district judge. My lord, this permission, my lord, is not necessary from the district judge in case of private Devottar, my lord.
Yes. So where is the infirmity? You can take this point before the tribunal.
Yes, but
So
my lord
take
has the
this point.
jurisdiction to
This does
interfere
not
with.
come within those. Maybe a wrong order. If it is a wrong order, forum is there.
But my lord can clarify this, my lord. Without going into the merits, my lord can clarify this, my lord.
No, no. This. The petitioner has
Wait, please, your lordship, my lord.
Yes.
Lord, this is an encroachment of a public road. Private respondent is there. He has received to accept the, my lord, the service. He has received to accept the service, my lord.
Refused to accept.
Yes, yes.
It's a good service.
Yes, yes.
State.
We have already served.
Who is appearing for the state?
দাঁড়িয়ে যান না Mr. Dey is there, my lord. He can take care of everything.
Mr. Dey, yes.
Small matter, my lord.
So why the state advocates are not appearing?
I can't. This is a very.
Would appear. Yes, yes. What is this?
My lord, kindly have a look at page 120, my lord.
120.
120.
Yes.
Because prior to that, all of the deeds, my lord.
এই একটা কপি দাও সুব্রত
একটা কপি আছে এখন দেখুন পরে দিচ্ছি
Give a copy to Mr. Dey. Yes.
My lord, we filed a, my lord, the letter of complaint addressed to the, my lord, the executive engineer, Public Works Department, Roads, Krishnanagar Highway Division, Nodia, for the removal of the encroachment by initiating a proceeding under section 10 of the, my lord, the West Bengal Highways Act of the 1964. That has not been, my lord, the
Executive engineer or the assistant engineer, which is the appropriate authority?
Executive engineer.
Executive engineer, assistant engineer. My lord, according to the provision 10(1), please see this.
Not the executive.
Not executive. Assistant engineer.
Okay.
Assistant engineer has been implemented. You have not implemented.
Your executive engineer has been implemented, not the
Please implement the assistant engineer.
Assistant engineer.
Yes, Mr. Dey.
Yes, my lord.
Consider this.
My lord.
If it is found a highways act to the
my lord.
West Bengal highways.
আছে my lord এর ওখানে আছে বইগুনা কোথায় গেল my lord ও চলে আসছে
ওইখানে আছে
দিয়েছে my lord তুমি আছো না এই তুমি হলে চলে এসো my lord my learned friend is there my lord
you are appearing
yes my lord
14
না 14 তো 14 তুমি দাঁড়াও এই নাও
so Dhar, in none of the matters you are appearing.
I was on my
previous two matters you have not appeared. This matter you have not appeared.
Today is hearing day, my lord. I am before division bench.
So you will not attend the motions. Senior advocates have to adjust.
শুনতে আমি
assistant engineer বলবে the assistant engineer or the executive engineer has not been mentioned in the section 10.
Yes, assistant engineer is the appropriate authority, Mr. Dhar.
Yes, under highways
assistant engineer.
engineer.
On the prayer of Mr. Dattol Yes.
My lord, in this petition, my lord, the petitioner has challenged the order of the my lord, land acquisition officer, my lord, which is my lord, page 94.
Challenge the order of land acquisition officer.
My
Yes.
lord, this is the my lord, third round.
Third round.
Third round. Previously moved in 2011.
Who is for the state?
15. I'm for the state, my lord.
Yes.
95 page. LA case number, my lord. 255 75 76. 0.11 acre land. On 9/6/2025, the order amount has already been paid, my lord. He came before here for enhancement.
Just paid for enhancement.
Yes,
my lord, they have not calculated the as per my lord, local market value. They have not calculated. I have
All right. What happened to your prayer for enhancement?
no, it has been rejected.
Rejected, my lord. Page 95, my lord.
Page 95 today heard the petitioner at length, verified vividly all records. I have annexed all the local.
Petitioner has been paid such and such, which was determined as the act was repealed. The undersigned has no order to calculate.
In that area, my lord, per decimal my lord, rate is my lord, more than 1 lakh. They have calculated 11,000 per decimal. They have not, my lord, as per law, as per my lord, Act 23, my lord, they have my lord, 13, my lord, they have not taken the my lord, local my lord, sale deeds as for consideration.
This was under Act 2 of 1948.
48, my lord, the Honorable Court directed in 2015.
Act 2 of 48. Act 2 of 40.
My lord, local market, my lord, it has been,
So what?
It has been admitted in.
So what? You will not pay anything.
My lord, I paid.
How that is to be calculated under Act 2?
My lord,
Act 1
The provisions, rules of Act 1 will follow.
my lord, my lord, page 48 is the order of the my lord, Honorable Single Judge, in which the Honorable Judge my lord, was pleased to, Honorable my lord, Justice Ashok Adhikari, as the lordship then was, direct the authority to calculate the compensation at the present market value.
Where is that?
My lord, page my lord, 48.
48.
My lord. That of the assets, my lord, in low price, I made my lord, contempt
All
application.
right. The petitioner has challenged the
No. That was the same with the
by the
hindrance.
same petitioner
Same petitioner.
against the same private respondent.
Same private respondent. With the allegation of hindrance of ingress and egress. Kindly see the order. That was
অর্ডারটা আছে আমি আপনাকে অর্ডারটা বলতাম এটা লিখে নিতে পিটিশনে
it's completely silent, Balaba.
পুলিশ ইন অ্যাকশন ছিল
Yes, encroachment has been removed. Some debris were there, that was also removed. Then what remains?
My lord, again,
And what is the civil suit for?
shoot for shoot ওদের shoot না আমাদের the suit is filed by the mother of the petitioner
Mother of the petitioner against you
against me
for
declaration and that removal of this stone chips and debris. তাহলে কি করে হবে? And my lord, this Himanshu Mondol was the pro forma defendant.
Gopal Sarkar.
Gopal Sarkar is the defendant and pro-defendant Himanshu Mondol, son of late Pradeep Mondol.
Have you disclosed this filing of the suit in this writ petition?
My lord, I don't find disclosure in the petition. My lord, let me come back tomorrow, Mr.
What tomorrow?
Jayad Hossain is on record. That let me come back to ascertain. This has not been asserted in the writ petition. I have seen.
Client knows it very well. The client knows it very well. Ashun. The petition
My lord, I am appearing for the state. I have already shot for.
Microphone, madam.
I have already shot for the instruction and before to the authority concern appropriate authority, but instruction has not come yet. Kindly keep it next week, my
Let
lord.
me see whether instructions is necessary. Yes.
This is relating to, my lord, the plot of land for relinquishment. Not relinquishment, my lord. The petition is the owner is the plot of land, RS plot number 130. But the state is claiming that that has been acquired according to the information was sought for under the Right to Information Act. Kindly turn to page 17.
Relinquishment
does not apply here, my lord. The point is
a portion of a plot was acquired.
No, that is the RS plot. I am claiming title number RS plot number 130. I wanted to make construction by mutation and other things. This authority saying it is the subject matter of acquisition. I approached the concerned authority. Now I'm going to page 17 P2 to this application.
17. Yes.
Your lordship will find overlapping. OL means, my lord, the overlapping register. According to report, concerns RS plot number 130 such and such is not noted against any LA case, but CS plot number 130. So this is the only thing. If they clarifies that it is not, because by saying this, they practically again put me into another.
Where is the CS and RS record of
CS, my lord, the RS record is with me, my lord.
Where is the CS record?
CS record is not, because I am not claiming anything to CS. They are saying that CS. So the state can come up with and say that this is the CS and RS.
Usually, Mr. Rai, if a Bata plot is being created, that a separate number is given. Otherwise, the numbers.
That is precisely why this has been sought for. They themselves said it is not. I could have understood. They said, no, this is the plot. So let them take instruction on my representation.
So you are claiming ownership in respect of RS plot number 130.
Yes, that is my deed itself.
According to them, that is not subject matter of any
acquisition. But
CS
that number is acquisition. So even if it is their case that it was converted to subsequently CS 130 is converted to RS 130, then my lord, I have to take steps.
Mr. Rai, this representation is
that is relinquishment. That order is
can give you a liberty to file a fresh representation, because this representation relinquishment, they will pass another order and it will again come up.
That is precisely, my lord,
give you a liberty to file, because this is what you want.
Yes,
because
yes.
Prayer is to send a letter of relinquishment and other things. It means that it was acquired, not utilized, relinquishment, whether there is a provision or not at the relevant, all these things will come up.
Then, if you logically consider it another way, I cannot ask whether I have asked whether this plot is subject to acquisition. They said no, it is not acquisition. Then, my lord, I am in a suit. Then, my lord, I have to file a suit for declaration. Because they will not come up with, so I cannot pray anything. This is declaration.
I'm only saying that you can make a representation. Not this representation, considering maybe a difficulty.
For relinquishment, the word relinquishment is troubling.
That is thing, because the prayer is also
the relinquishment.
Issue a letter of relinquishment, meaning thereby
that it was
subject to some proceedings. You have not utilized, relinquish that. That's not your prayer now.
No. That is not
because your specific case is that was never acquired, and to some extent they are admitting your plea, but saying there is a dispute with regard to the.
If the state come for a report on that basis, otherwise,
My lord, Amit Gupta sir, in this matter.
Who is appearing?
Amit Gupta.
Amit Gupta.
Amit Gupta.
Where is he?
He is ill. Because he is ill, he does not come today. He says next week.
File a report.
That will suffice the purpose.
In the writ petition, it's a copy paste of the representation.
Not to that extent, my lord. Something is there.
Tell me what is there.
If your lordship can turn to paragraph 3, paragraph 4. Before that, my lord, I am drawing your attention so far my title, paragraph 2.
Where is you have annexed the deed?
Yes, I have annexed the deed. The schedule, my lord, will find.
Plot number 130.
Page 13, your lordship will find the schedule.
There you have CS plot number.
No, that is in the deed itself is RS plot. That is why precisely, my lord, can you consider page 13? তফসিল বর্ণিত পরিচয়।
Your vendors chain deed.
In the RS, it is solo owner in the name of my vendor. If the CS it was acquired, then my lord, RS probably at that point of time, my lord, the record of rights has been done in a. So if that be so, my lord, that is why precisely. And accordingly, I
You
have
have not
said.
annexed the entire deed, Mr.
Yes, yes, yes. The
Sorry.
schedule, my lord,
Which page is the
page
schedule?
13.
13.
2 number পাতা at the top, my lord, will find 2.
13.
Page 13, 1, 3.
Yes, but it's not the complete copy. Page 16. There is something after 16. Not something, many things after 16. It's not the complete copy of the deed.
কপি আছে একটা আছে
From your Sheresta, Mr. Rai, what is being an incomplete copy of a deed you have annexed?
This is the last page which has been missed out. টাকার যায় only টাকার যায় and the RS subsequently, my lord, I have obtained the RS copy. এই যে
Yeah, it is not written RS or CS.
No,
only 130 number dag.
Yes, that is why the
deed also does not specify RS.
That is the
boundaries. No boundaries.
Yes, yes, তফসিল
Where?
ওটাই তো গন্ডগোল হচ্ছে
Where are the boundaries? Mr. Rai, file a civil suit.
No, civil suit. Boundaries there.
Demarcation is also not there. Boundaries are not there. It does not say CS or RS.
If you logically consider. If your lordship may allow me to supply the entire copy of the deed wherefrom it will appear, my lord. Not only that,
Rai, I cannot understand. Please kindly come to page 15.
Yes.
It's the internal page 5 of the deed.
Yes.
You have a complete copy of the deed with you.
Yes, yes.
Please kindly come to internal page 5 of the deed.
Yes.
It says bottom. তফসিল বিকৃত সম্পত্তি পরিচয় তাহার চৌহদ্দি. Next paragraph 6, no চৌহদ্দি, nothing.
Paragraph page 6, my lord.
Yes, page 6, nothing. Page 5 ends with schedule with the boundaries. Page 6, something else. I think different copies of the deeds have been annexed.
তাই আছে তো এই যে এইটা I'll file supplementary including the original. These are 2 copies, my lord. Pages are misplaced. It is my fault. Next page your lordship will find.
This is again page 7.
Yes.
Rai, I think some
deeds
other
pages
deeds
has been
copies that has been.
And not only that, there is a boundary. The map also there is there.
That is what I am saying. That
The map is also there.
The deed you have annexed, nothing.
That is where page 13 I have gone to.
But unless Mr. Rai, you give them a complete copy.
Yes, certainly.
They also cannot file a report.
I will file a supplementary affidavit. After that, my lord, in the meantime, I will survey copy, take a report on the basis of that, my lord, your lordship pass. That is my fault.
Because unless you give a correct copy of the deed, they cannot also
yes
file a report. Mr. Rai, learned advocate appearing for the petitioner State.
Separate
case ছিল।
আছে। আচ্ছা, separate.
For the state.
I appear for the
Oh, you are
state
appearing. Extension of entry was there was a mistake in the recording of the number of the.
So I believe
দেখি
this
ফাইলটা
matter
দিন না।
can be disposed of because petitioner
Matter can be disposed of by directing the authority to decide my representation.
Yes.
Madam.
That
This
is
is the matter, my lord. What happened, my lord? My lord, the petitioner was granted a mining lease, and thereafter, my lord, it didn't continue the mining, didn't even commence the mining activity. The steep resistance came from the local.
I'm extending the interim order. I'm keeping.
Kindly take it this matter, my lord. Any day, my lord, it will take 5 minutes.
What was the interim order?
Interim order not to encumber the property.
encumber the sand.
Your lordship will find in 18th of September, now 5th of December 2023, the order was passed, interim order. The respondent are restrained from
Interim
creating any
order
third party interest.
is extended till the end of the month of.
Get
18 years.
এইসব কাগজপত্র ঠিক আছে? কাগজপত্র ঠিক আছে?
Civil dispute is there.
No civil dispute.
No civil dispute.
Only মাটি.
From the appearances of both
Only
sides.
মাটি.
Yes.
Here, my lord, the requisition was done.
Act 2.
Act 2.
Then
Subsequently, notification was issued for de-requisition of the same.
no, not followed by 4(1)(a).
No, de-requisition.
De-requisition. Then
That your lordship will find. No.
what happened after that?
After that, still, my lord, I cannot enjoy the property because of name of that authority still.
Yes, Mr. Banerjee. After you have
the
de-requisitioned that,
allegations are very vague. Kindly come to paragraph 8 and 9, my lord. Somebody is disturbing. Who is disturbing? How disturbing? Nothing is clear. Kindly see paragraph 8 and 9. And he has made a representation. Let that be considered. No specific, my lord, allegation. Illegally causing
where is
hindrance.
the order of requisition?
That
Previously,
Sorry,
my lord.
de-requisition. Where is that?
Yes.
He has annexed that, my lord.
Your lordship may kindly consider page 53.
Allegation is not of not taking over possessions, causing hindrance.
Yes.
Very vague. We shall consider the representation. Kindly see page 8. I'll just place.
So where is the order of de-requisition? Where is that?
No. That your lordship will find. Draft is with me, page 49 P2.
But later it was withdrawn from acquisition.
Yes.
No,
And next,
after that,
page 52.
Mr. Banerjee, you are also standing by this information.
You know, this is a particular acquisition process. I don't know whether something subsequently has taken place or
Page
not.
53. Page 53.
Page 53.
Yes.
53.
This
It
is of
appears
11th of April 2025. This is the
Yes.
information. After that, you have initiated any acquisition proceedings. If that
No.
is so, Mr. Banerjee, I can
Page
record
54.
this. I will.
I don't have instruction whether after this anything has happened. My
Page
humble
54.
submission, my lord,
As on this day.
kindly sees the nature of allegation. It
Page-
is not that we have taken over possession.
Page
Para
54.
Para 8 says that the authority is causing hindrance regarding enjoyment. That is very vague. So he is not saying that he is not in possession.
So you take instructions.
Or your lordship.
If you say that you stand by this de-requisition and you have no claim,
no further acquisition process.
No claim. Yes, till now it's there is no acquisition. You have no claim with regard to this property. I leave Mr. Rai free to.
Page 54. Page 54.
Yes.
Can you consider page 54?
Yes. What is page 54? That's the representation.
No, page 54. P4. After
Name is recorded.
How?
I put this question to myself.
Now, but kindly consider if an acquisition process is started subsequently, unless it is completed, and even after completion, my lord, recording the name of the government, it might take some time. So, continuation of the name will not per se give him title. But not,
Mr. Banerjee,
I have to
please
come up
take
with
instructions. I will record that.
Yes, that
It's
is
a mere erroneous recording. He will text us, and if he texts us for correction, he will not give any objection to that, and he will see that this correction of the record of rights is being done expeditiously.
পশ্চিমবঙ্গ সরকার।
Take instructions, because that's
এটা কবে
only
চেয়েছে?
grievance.
এটা কবে
And if
চেয়েছে?
that is rectified, if some private parties are causing hindrance,
Yes, that I am out of court.
you will have to
That-
approach the appropriate forum.
That is why I was saying, if you can pass a reason order, we can come back. Kindly keep it pending. We can pass. Representation is there. We can take a decision and come back on that.
What decision you will
Since
say?
he's saying there is
After this,
obstruction.
after this, Mr. Banerjee, what decision you will take? After derequisition, you will relinquish.
7th
This
October.
prayer is all matters, all representations drafted as per the instruction of Mr. Rai, relinquishment. What relinquishment after derequisition?
No, they have to either to declare, because still it is in that name.
Derequisition. No, this is correction.
This is not correction of record of rights. Still they are claiming. That is why by writ petition.
That is
I shall come back with this.
That is why they have at all any claim or not.
And today, what is the status? Because 7th October, he has given the status. Today's status, I'll take that also, and whether anybody is disturbing his possession.
Anybody, my lord, apart from state, whether state has any.
If derequisition, no state will not possibly, my lord,
That
cause
is why
hindrance in his enjoyment.
precisely, my lord, the record is still there in possession showing in their records. It is the records of the state.
I shall come back with instruction.
It is the record of the state.
Or consider the representation.
No, consider.
Why? Let them take a decision.
In view of the nature of the allegation, that somebody is causing hindrance. It is not that his possession has been taken.
It will. Only
আরেকদিন হবে।
না না আরেকদিন হবে না রে ভাই। Only that report will come. If it is on the face of the record, I am claiming anything.
Petitioner claims to be the record.
Of affidavit, my lord.
Report in the form of an affidavit.
No, no, kindly, my lord, it was 2 weeks because.
Huh?
Give me 2 weeks, my lord, then.
2 weeks? Why?
Because I don't know when the report will come. I'll have to draft it and get it affirmed by then. It might take
To the report. Report you can file.
Report I can file.
তাহলে শুধু affidavit টা লেখার দরকার নেই, file a report. Yes, yes, what is this next matter?
My lord, Mr. Shamimul Bari appear in this matter. He's engaged. Mr. Shamimul Bari
Yes, yes.
appear in this matter. He's engaged in courtroom number 551. I'm praying for not to be.
On the prayer of the learned advocate for the you are appearing, Mr. Banerjee.
Monday going? Monday. My lord, will you not to kindly make that Monday? Because
next week করে দিন, sir.
Monday.
Adjourn for this week করে দিন, ঠিক আছে? Yes, who is appearing? Yes.
I am appealing for the state, my lord, led by Vivekananda Bose.
Yes.
Lordship, the petitioner became homeless by the 1998 Malda flood, and then they have been residing a small portion of PWD land. But there are also similar other families who are also residing on the PWD land. Then one eviction notice under section 10(1) of the West Bengal Highways Act of 1964 for removal of encroachment was issued by the authority upon me. Then
remove the encroachment.
Lordship,
Remove the encroachment.
Let me submit, Lordship. On
Yes.
14th October 2025, although prior to that, I've already sought for permission for stay in the land, but which is pending for adjudication under Section 8 of the West Bengal Highways Act 1964. My only humble prayer before your lordship, kindly direct the authority to consider my application of 23rd September 2025. Until then, stay the notice of eviction.
Show me the power of the authorities to grant post facto sanction under section 8. Show me.
Lordship, kindly consider my only humble prayer. That is my bread and butter, Lordship.
I can direct. Show me the authority has the power to consider that. To grant post facto permission under section 8.
Lordship, kindly consider my application, Lordship. Kindly
Let
consider
me
my
show
application.
that
Lordship. This is my only bread and butter, Lordship.
Cannot be done.
They are
Cannot
very
be done.
poor people, Lordship.
Everyone
Kindly
come
come
up.
to consider my only.
Everyone will come up, say bread and butter, section 8, after constructing permission.
Lordship, where
Not done.
go, Lordship? Kindly consider my application.
Demolish, pay for permission. I will direct them to consider. First demolish. Yes, Mr. Naik. Yes, demolish. You have heard the observations of the court.
My lord, this is the construction, my lord.
Maybe.
This is the construction.
For me, under the law, the authorities have the power to grant post facto sanction.
But my lord, from the date of inception, my lord, I never claimed the land that it belongs to me. Even my lord,
Section 8 is for that.
Yes,
You have a right. You can encroach. Section 8 gives you permission to encroach, but upon previous permission. Now you are saying you have encroached. They have issued a demolition notice. Now you are applying under section 8. Show me the power of the authorities to grant post facto permission. Please satisfy me on that.
ঠিক আছে আমি দেখে নিচ্ছি কিছু দরকার নেই
but my lord, it does not expressly bar the authority to consider my application.
Show me the power. Authorities have to act only as per the power vested upon them under the statute. They cannot do anything and everything which is not expressly barred. Law is other way around. They can exercise powers which are only vested upon them under the statute.
My lord, can
that's the distinction. An individual can do whatever he wants,
true, my lord.
except
My lord, can the state pick and choose, use the pick and choose policy?
That's
my
a
lord?
different thing altogether.
Everybody is equal before
So,
the eye of
no,
law. My lord,
if there is any encroachment, you can very well, I give you liberty to approach them for removal of other encroachments, but that does not authorize you to encroach and remain in the property without obtaining prior
My lord,
permission.
what has happened, my lord, due to devastating flood which occurred in Malda, my lord, I have to, if
No,
not
no.
only me, my lord, the entire area,
This
my
is
lord,
not
the
right.
people who are staying, my lord, they have
Since when you are there?
last 25 years, my lord. I have the documents, I have annexed with the written notes of argument before the authority, my lord. That is on record, my lord.
Maybe after the notice was issued, it dawned in your mind
No,
that you have to
I
pay for
never
permission.
disputed that. It does not belong to PWD, my lord. Can you consider my bona fideness, my lord?
No, that's another way.
There's a lack
Then
of bona
you cannot make a representation. If it is not before the with the PWD, your
Kindly, my lord, consider
representation
my
does
written,
not lie before the PWD to obtain permission.
my
I will
written,
record that and I will say yes. Then the authorities will be free. If they find it is encroached upon them, so your representation does not lie if it is not on
my
PWD
lord,
land.
if I
The
had
Highways
the,
Act will not apply.
my lord, if,
Section 8.
my lord, if I had the intention to, my lord, delay the proceedings, my lord, I would have stated that
Not a question of delaying.
my lord,
It's a question whether they should be restrained from taking further steps under Section 10, or you have to be granted a post facto permission under Section 8.
let the
These
authority
are
consider that,
issues.
my lord. My lord, I've never used the dilatory tactics, my lord. Even
I'm
the
not saying dilatory
my lord,
tactics. I'm saying show me whether over and above.
my lord, kindly let them consider it. My lord,
Nothing
let
is
them
there.
consider it, my lord. I'm having an aged parent, my lord.
Mr. Nayak, it's not that any representation you will make and mechanically an order will be passed direct in consideration. If the authorities do not have the power to consider that representation, that direction cannot be passed. Show me the authority has the power to consider such type of representation.
Let me come back, my lord. Let me go through the provision, my lord. Let me come back tomorrow, my lord, or Monday, my lord.
After going through the provision, you have applied under
My
Section
lord.
8, Mr. Nayak.
Let me come back, my lord. Let
You are
me
led
have
by
an
Mr.
opportunity
Dhar.
to satisfy.
You are led by Mr. Dhar.
Yes, my lord.
Where is he?
My lord, he is on his legs before courtroom number 16.
He came here.
Yes, my lord.
Other matters passed over. Now in this,
Let me come back.
or looking at the merits of the case, he has not come.
Well, let me come back. Let me have an opportunity to satisfy your lordship.
Tomorrow? Not
Or on Monday, my lord. Monday, my lord. My lord, kindly take up on Monday.
only one, two sections we have to go.
My lord.
Section 8 and Section
My
10.
lord.
Grateful, your lordships.
Yes.
I'm deeply obliged.
21, yes.
And for the petitioner, my lord. My lord, number one respondent, Sapi, service not complete, my lord. Return the copy. So give me 1 week time.
Rectify the records. Who is appearing for the state? Mr. Bandyopadhyay, you are appearing. Have you served upon the state?
Yes, my lord. This is a
Please come.
Give me, my lord, 1 week time, my lord. Give
1 week time for what?
for my lord, for new fresh service, my lord. Respondent number 1, my lord.
Respondent number 1.
Yes, my lord.
Who is the respondent number 1?
The chief general manager.
National Highway.
Yes, my lord.
All right, you serve, but state you have served.
Yes, my
State has received.
Yes.
আচ্ছা, আসুন। The learned advocate appearing for the
Yes, my lord, in terms of my lord's desire, my lord, the paper books, my lord, have been filed on that day.
Paper book.
What about this one? Is this fine? My lord, we have also filed a compilation
Yes.
in the form of a paper book. You have this, Mr. Chaturvedi. You have this.
Yes, yes.
Yes.
Evidence? Is there a compilation of evidence?
No.
Did not make that.
We have not made, we have shared, exchanged each other, but we have not made.
Okay.
Yes.
Lord, the defendant number 1 is the appellant.
I can take the paper book and this compilation.
Yes.
Don't need to take this records for the moment.
Not for the moment. Not for the moment.
রাখুন এখানটাতে খুব দূরে রাখবেন না কাছাকাছি রাখুন yes
Lord, in a suit for eviction under the 19
who are you?
Yes, Lord, I am the defendant appellant in a suit for eviction on the ground of subletting under the 1956 Act. Lord, judgment of affirmation.
Subletting only?
Only subletting.
1956 Act আছে Premises Tenancy Act. Yes. Decreed by both the courts below.
Decreed by both the courts below.
Yes.
Now, the suit was, my lord, as I said, for subletting and mean profits. Mean profit again concurrently, my lord, denied by both the courts below.
No cross appeal.
No cross appeal. My lord, among other issues, my lord, we have taken up right from the inception. And when I say inception, right since replying to the notice to quit, we took up a point that the status of someone who is claiming himself to be the landlord is hit by the doctrine of concurrent lease. By that I mean, my lord knows, my lord, that concurrent lease, my lord, the doctrine is
concurrent lease.
Concurrent lease.
Yes, concurrent lease principle is applicable in India.
That is what I'm saying. But it is, my lord, applicable in England, but in India, my lord, it is held to be, lord, not valid. And there are judgments to that effect, my lord. Our court, my lord, single bench, division bench, my lord, have held it. And typically in the context of the law that, my lord, presently we are confronted with, my lord, that is the Premises Tenancy Act. My lord, the appellant before, my lord, is a law firm. Now, as my lord knows, my lord, that the office
appellant law firm.
Appellant before my lord
is the law firm.
My lord, yes,
Both law firms. Appellant, respondent, both.
Why are you fighting?
Lord, if
you have other businesses, both of you.
If this is coming from my lord, I first, my lord, take it with folded hands, my lord, and I still say that
I'm not saying against only you. I'm telling to both of you.
But my lord, I have caught, my lord, I have caught it first. And when I say this, my lord, I say that insofar as the appellant is concerned, my lord, we are open, my lord, to any reasonable proposal. We are occupying, according to them, 1482 square feet. We are open to a negotiation of a lesser position on relinquishment of the balance part of it. We are open to negotiations with regard to the quantum of rent.
I think that will not help now. Let us.
No, since it came before my lord, it's
since you have said that both are law firms.
Yes,
that is why I feel that why are you, because you have, both of you have other businesses.
Yes,
you can perform it in a better way than.
Absolutely.
If Mr. Bose says that yes,
he is nodding his head, he has given his reply.
I am nodding my head to no. Not possible. I
Yes,
also,
yes,
when it first came, this is the first thing that fell from me. That please.
Yes.
So we proceed on minutes. So insofar as, my lord, the issue of, my lord, subletting is concerned, my lord, both the courts, my lord, have held against me But ironically, there is no local inspection in respect of the nature of possession, subletting, if any, the area occupied by the alleged subtenants. There is none. It's only on the basis of the evidence tendered on behalf of the plaintiff, and more particularly the plaintiff number, the PW1, that both the courts below have proceeded to hold that there was a subletting. I
Subletting is basically, Mr. Chaturvedi, is a finding of fact.
I fully agree to that.
Concurrent finding of fact by both the courts. So
until and unless perverse.
Yes, scope of challenge is very limited.
Yes.
Unless you can demonstrate that it suffers from perversity.
Yes.
Perversity meaning thereby some evidence.
Bereft of material record.
Yes. Non-consideration of any material evidence.
I shall.
Or consideration of some evidence.
Yes.
Which is not very material or irrelevant evidence has been taken. So that is the only scope.
Yes.
So that is on merits. And
Yes.
What is the ground on which it was admitted? Please
Yes.
take me to the.
I am coming to that. Now, my lord, the ground, my lord, is ground number 3 in the order of admission. My lord would kindly, my lord, take up my paper book, and my lord would kindly.
I've seen page 65, ground
Yes,
number 3.
65.
That is ground number 3.
My lord, kindly, my lord, comes to page 55
of the memo
of the paper book.
Yes. Oh, this has been couched in the form of a substantial question of law.
My lord, my lord.
Though it has been stated as grounds, but it's substantial question of law. In the order admitting appeal, it has been said ground number 3, but it appears it's framed as a substantial question of law.
Yes, yes. May I read, my lord? Whether the learned judge erred in law by not holding that the appellant was a tenant directly under the original owner, and the leases were granted to the plaintiff when the appellant was already occupying the suit premises as a tenant, along with other occupiers' licenses, and as such, the plaintiff cannot file a suit for eviction on the ground of subletting, particularly when prior to the grant of leases, the appellant was a tenant under the owner. Now, my lord, in this case, my lord, what had happened is, my lord, the appellant is a tenant in respect of, my lord, the suit property, my lord, since 1923. Under the respondent, initially under the predecessor of the defendant number 2.
Please kindly
Emerald.
Page 53. That's the cost title of the memorandum. Please tell me under whom
the predecessor of, my lord,
respondent number 2.
Of the respondent number 2.
So appellant was the tenant under the predecessor of respondent number 2 from 1923.
My lord.
Thereafter, it was transferred to respondent number 2.
Yes.
And you continue to be a tenant under respondent number 2.
I continue to be a tenant under the respondent number 2.
Then
in 1979, my lord, the lease is executed by the respondent number 2 in favor of the respondent number 1.
Lease by 2 in favor of 1. Yes, 79.
1979
for
a period of 5 years.
All right. 84. It expired in 84.
84. Right, it was permitted to expire. Then in 1985, my lord, another, my lord, lease is executed
for
a period of 5 years.
Another 5 years.
Another 5 years.
So it's 90.
89. With
89,
retrospective,
yes, 89.
Because of the retrospective effect given to the second lease with effect from 84.
So 89.
89. Thereafter, the plaintiff's case is that a letter.
When the suit was filed.
The suit was filed in 95.
So after the expiry of that lease period,
After the expiry of the lease period,
by 2 in favor of 1.
in favor of 1. Thereafter, the plaintiff's case is that the respondent number 2 issued a letter. This is not sometimes in on the 20th of April 1989. This letter says that on the same terms, the respondent number 1 shall continue with a right to sue. This is the foundation on which the suit has been filed by the respondent number 1 against me.
Suit filed by respondent number 1 against you,
my lord. So, my lord, the situation
and that letter, original letter, are exhibits.
1, 2, and 3 respectively.
Where is that? These are in the compilation.
No, those are not.
Exhibits are in the compilation.
No.
Do you have a copy of those lease deeds?
Yes.
Any?
Yes, Lord, I shall come to that. Lord, I shall address my lord. My lord, in so far as the content of the lease is concerned, my lord, my lord would find it, my lord, in course of what I show to my lord would find the relevant portion of the the lease deeds. Now, this, my lord, was the pith and substance, my lord, of the content of the plaintiffs. Lord, I shall only indicate 2 paragraphs of the plaint, my lord, to show as to what, Lord, is
in this compilation.
Lord, the plaint, my lord would get in the compilation.
You can tell what document Mr. Bose can help you
with the dates.
Me with the page numbers, because we have prepared from some other document.
My lord would find that at page 1A.
1A.
My lord.
Yes.
Lord, I shall show, my lord, paragraphs 2, 4, and 5.
Yes.
My lord, paragraph 2, the defendant number 1 being the number 2 being the pro forma defendant is the owner of the said premises number so and so. The defendant number 2, my lord, demised the said premises in entirety in favor of the plaintiff by a registered deed of lease dated 9th May 1979, commencing from the 1st May 1979, which as renewed by another registered deed of lease dated 15th February 1985.
Any page has been missed, because after paragraph 2 it comes paragraph 4.
Milord, paragraph 3 is missing, Milord, in my
no, is there any
no, it's an omission. It's an omission at the inception.
So only numbering is wrong.
Yes.
Nothing has been left out.
No.
Yes.
The defendant number 2 demised the said premises in entirety in favor of the plaintiff by a registered deed of lease.
Yes, 2 and 4 are these facts which you have already stated.
Yes. Now, kindly, Milord, sees, Milord, paragraph 4. Upon grant of lease, a letter of atonement was issued by the defendant number 2 to the defendant number 1. The defendant number 1 was asked to atone the tenancy in respect of room number 8 on the first floor.
Room number 8 is the suit property.
On the first floor of the premises, in favor of the plaintiff, defendant number 1 accepted the plaintiff as landlord and started paying monthly rent to the plaintiff on and from the month of May 1979.
That is from the date of the lease, past lease.
My lord. And my lord would next line find, my lord, the rent is, my lord, page rupees 454 payable according to English calendar month. Now,
and you are paying to the
atoned so-called landlord.
Yes, so you are paying rents to the plaintiff.
To the plaintiff. But paragraph 5, my lord, would be of some relevance. That the defendant number 1 has wrongfully and without the consent of the landlord in writing sublet and or transferred the possession of different portion of the said room number 8 on the first floor of the said premises in favor of the following concerned person whose sign
the case of subletting.
And these are, my lord, the names. Out of these, my lord, kindly see serial number 1. He is the defendant number 3.
The defendant number
3.
So one of the alleged subtenant has been implemented as a party in
My
the
lord,
two.
my
Yes.
lord, my lord. And kindly
That
see
is number 1.
1.
Yes.
Then paragraph 6, the case made out is that the defendant
Number 1 is contesting. Defendant number 3 is contesting here.
and not here. I do not know.
You must be knowing Mr.
No,
Chaturvedi, whether he is contesting or not.
no, he contested in the court below, but my lord, here, my lord, I do not. I was only inquiring my advocate to record, my lord, whether any intimation has been given.
That is why I'm
Yeah.
not saying, not personally.
No, no, I understand.
Appellants will
Yes,
know.
yes. So he contested in the court below. But paragraph 6, my lord, would find that the defendant number 1 is occupying a very small portion of room number 8. So this is, my lord, that substantial portion has been let out to the persons named in paragraph 5. And then, my lord, page 5, internal page 5, paragraph 8, the defendant by a letter dated 16th October 95.
So this is the notice to quit.
My lord.
13(6) notice.
My lord.
Yes.
And
then other usual averments.
Yes. And then, my lord, the prayer is at internal page 7, my lord, the eviction and mean profits.
Mean profits
declined by both the courts.
Declined, they have not preferred any appeal.
My lord. My lord, kindly now, my lord, takes up, my lord, the page 17A of this compilation.
Yes.
My lord, kindly sees, my lord,
written statement.
This is my written statement.
Yes.
My lord, kindly sees, my lord, in internal page 3 of the written statement, paragraph 2.
Yes.
I'm sorry, my lord, continuation of paragraph 1, but the third line starting with the words. The defendant number 1 further states that at all material time, the defendant number 1 has been and still now is a tenant under the defendant number 2, the landlord of the said premises. And the first line on the same page is the defendant number 1 states there is no relationship of landlord and tenant.
So you have disputed the landlord and tenant relationship between you and the plaintiff. And your case is that you are a tenant under the respondent number 2 here.
My lord. Now, although, my lord, the plaintiffs, my lord, have taken up a point that after having accepted the plaintiff as my landlord, having paid rent to him, whether I can challenge, my lord, the landlord-tenant relationship, I say that I am not challenging the status per se. I am challenging your derivative title, which my lord knows, my lord, that
not bar under section 116 of the evidence.
Grateful to my lord. Then, my lord, kindly sees, my lord, paragraph 2. My lord, the third line starting with the words, defendant has been in use and occupation of room number 8 as monthly tenant according to English calendar month since February 1923.
So this is your specific statement.
My lord. Under one Mongni Ram Bangor and company until the premises was transferred by the said firm in favor of the defendant number 2. And thereafter, under the defendant number, this is not surplusage, I understand. The defendant number 1 had duly paid the rent as such, the tenant to the defendant number 2 and its predecessor in title. Now, Lord, kindly sees the next paragraph. In or about May 1979, plaintiff represented the defendant number 1 that the defendant number 2 had executed a lease deed of the said premises so and so in favor of plaintiff subject to tenancies of the existing tenants of the said premises with authority to collect rent from the said tenants. The plaintiff further requested the defendant to pay the rent of the said room to the plaintiff. Relying upon the aforesaid representation of the plaintiff, the defendant had paid the rent to the plaintiff as lessee having the authority to collect the rent. The plaintiff did not produce any copy of the lease to the defendant number 1. And then, Lord, now kindly, Lord, comes to Lord, the next paragraph, the third line. The defendant number 1 further denies that the defendant number 2 treated or could have treated the plaintiff as a tenant of the said premises in entirety on the terms and conditions mentioned in the alleged deed of lease. The said allegations are vague and ambiguous. I say that you cannot be the lessee in respect of the entire premises in view of a pre-existing tenancy occupied by me. Kindly recollect, section 105. Lease of an immovable property is a right to possess the property.
To enjoy.
Right. If I am already enjoying,
Transfer of property activity.
I have copies, kindly.
মোটামুটি কপি মিস্টার
Yes,
চতুর্বেদী ততক্ষণ বার করুন। Yes.
Now, kindly see is paragraph 6. This would be a little important.
Yes.
It
Paragraph
appears
6.
Paragraph 6.
Yes.
It appears from the deed of lease dated 9th May 1979 that the defendant number 2 thereby granted a lease of the said premises with the existing tenancies held under the defendant number 2, including the defendant number 1, for a period of 5 years commencing from so and so and expiring on so and so at a monthly rent of so and so, subject to the covenants to be observed and performed part of the lessee, including inter alia the covenant to yield and deliver possession of the demised premises, together with the buildings and structure that may be erected thereon at the expiration of the term herein granted. Kindly seize this, subject to such tenancy occupancy and or sublease as may be created by the lessee in pursuance of the liberties given to the lessee herein contained. And then paragraph 7, the lessor shall issue letters of atonement to the existing tenant for payment of monthly rent to the lessee. This presupposes
the right to evict and to realize area rents.
So this presupposes that there are existing tenants. I join an issue here, and this is the question of law which we have been consistently raising, and which has been admitted as the substantial question of
Show
law.
me the issues framed on this.
Yes. I am about to finish on the written statement. I shall come directly to that. Then paragraph 8, upon expiry of the demise terms of 5 years granted by the said deed dated so and so, premises reverted to the lessor, whereupon the plaintiff lessee was obliged to vacate and deemed to have vacated and made over the possession of the premises to the defendant number 2. Quite after some time, the expiry of the said lease dated so and so, the plaintiff requested the defendant number 2 to grant a lease of the premises all and upon the terms and conditions to be agreed upon between the plaintiff and defendant number 2. Pursuant to the said request, the defendant number 2 executed a fresh lease on the first day of February 1985 for a period of 5 years, which deemed to have commenced from first day of May 1984 and expiring on 30th April 1989, together with an option for renewal of another term of 5 years at a rent of so and so. The deed of lease dated so and so inter alia contained, lessor is solely and absolutely seized and possessed, that the land building comprised in so and so old possessor together with the motor pumps subject to the several tenancies in favor of the monthly tenants, but otherwise free from. The aforesaid recital bears out that the tenancies subsisting on 15th day of February 1985 were held by the tenants concerned under the defendant number 2, that is the lessor.
Yes.
And then paragraph 10, this defendant states that the aforesaid lessor's covenant to execute the letter of atonement in favor of lessee with authority to collect the rent from existing tenant or to sue the said tenants as herein before mentioned in paragraph 7 hereof was not incorporated in the later lease dated 15th February 1985. Kindly appreciate
Where are those two lease deeds?
Exhibit 1 and Exhibit 2. I shall come to that. The absence of the said covenant makes it clear that the lessor had neither atoned the tenancies nor had given authority to the plaintiff to collect rent from the tenants, nor to sue the tenants on any of the grounds whatsoever. And then Milord, paragraph 12, Milord, I have said that on representation we have continued to pay the rent.
So that's your defense as against Mr. Bose's stand that you have paid rent, so by payment and acceptance, a tenancy was created.
And
so that is your defense against that on a misrepresentation or a false representation, whatever name called, you have paid rent.
So this is, Milord, the on factual part, how defense case on facts. Kindly come to paragraph 14, where I raise, Milord, the issue of locus standi. This defendant denies that any letter of atonement was served upon the defendant by the alleged landlord as a lessor, assuming but not admitting that any such letter of atonement was served upon this defendant. The same is not valid or binding upon the defendant without the consent of the defendant, inasmuch as letter of atonement is intended to and has the effect of converting the tenancy of this defendant under the landlord, defendant number 2, into a subtenancy under the plaintiff. A mere lessee for a restricted period of 5 years, thereby depriving this defendant of its rights and privileges protected under the law of the land. This defendant further states that the question of atonement arises only in case of absolute assignment by way of sale of an immovable property, which creates a privity of estate between the subsisting tenant and the purchasers. A restricted assignment by way of grant of a short-term lease of 5 years does not create any privity of estate between the lessee and the tenant of the property holding the lease. But this, Lord, has been held in quite a number of judgments.
Now, what is the issue on this?
Now,
what is the issue framed on this?
Lord, with deepest of respect, this has been taken care of, Lord, in under the umbrella of maintainability. Is the suit maintainable?
All right. So what is the finding on
the
this?
suit is maintainable, but there is no finding with regard to section 54 or section 105 of the TPR.
Show me the finding of the trial court.
My lord. Lord, kindly, Lord, only permit me, Lord, to show paragraph 18.
Yes.
This is, Lord, with regard to subletting, Lord, what I have said. But I, as an officer of the court, Lord, I should be candid that I have admitted that there are people who come during the court hours and occupy the space, Lord, in course of, Lord, professional relations that we have, but I have neither parted with the possession in absolute and entirety to them, nor they have any exclusive possession, which, Lord, is, I'm sorry.
You have a control, Mr. Chaturvedi. I'm asking you.
Yes, I did. My evidence would, in my evidence.
Control.
In my evidence, I shall show.
So you can take physical control today itself of the other portions of the balance portion. Mr. Chaturvedi, subletting means you do not have control. Yes. License means permissive.
Yes.
So you can, you have only allowed, you can, it's fully under control. If I ask you, can you physically take possession of the entirety today?
Lord, I align my answer to the first submission that I made, that I am ready to relinquish a major portion of the tenancy today. I am.
What a major portion, Mr. Chaturvedi, there lies the. If you say the entire portion of your tenancy,
no, there.
If you are not in control of the entirety, then it's subletting.
My specific
then
case is
subletting.
My specific case. Kindly see my specific case, which went undemolished, and there was no local inspection.
Inspection is not necessary in view of this specific admission in the written statement.
Lord, I am again. Lord, kindly see what is my admission. I am saying that in course of the day, for professional assistants, advocates.
Under what consideration, Mr. Chaturvedi?
No consideration. That is my case, and they have not been able to, my lord, controvert it. Although, my lord, judgments are that the consideration part, the landlord
That is
is.
why I'm asking you, without any consideration, so you can take physical control of the entire portion.
Yes, yes, that is my specific case, that I am in exclusive possession.
Yes.
Lord, I would be failing in my duty if I do not indicate, my lord, what is my specific case.
Yes.
And thereafter, Lord, paragraph 20.
Paragraph 20.
My specific case, insofar as the locus standi is concerned, in terms of what I submitted in paragraph 14, third line of paragraph 20, the plaintiff has no locus standi to serve the alleged notice, as there is no relationship of landlord and tenant with the plaintiff and this defendant.
Yes. So you have specifically denied the landlord and tenant relationship between the plaintiff and yourself.
My lord. Now,
and your case is that the relationship of landlord and tenant is between you and the respondent number 2. Who is the defendant number 2 in this suit?
And on the representation made by the plaintiff.
That's your defense against their case, that relationship was there since you have paid rent to them.
And there is no case of default, no ground of default also.
No, it's only
Subletting.
Now, first is with regard to the maintainability of the suit, whether they have a locus standi.
My lord.
If you succeed on that, other things did not be gone into.
My lord. Now,
And, even if you fail on that, then whether you can succeed on the
other ground,
subletting, that is to be
my
taken
lord.
care
My
of.
lord.
So let us kindly come to the first ground.
My lord.
Where is the issue? How it has been dealt with by the trial court?
My lord.
So you want to place it from the other paper book, smaller one.
My lord, kindly.
Yes, place it.
Lord, kindly, Lord, comes to page 6. 9 issues are framed.
Let us go to the maintainability issue, or whether there is any landlord-tenant relationship, any issue has been framed.
Yes.
You can place only those 2 issues.
My lord. Lord, kindly sees internal page 6.
Yes.
Lord, kindly sees the issue number 6. Is there any landlord relationship of landlord and tenant between the plaintiff and the defendant?
So effectively, this is the relevant issue. Whether there was landlord-tenant relationship or not. If there is landlord-tenant relationship, then they can file a suit. Basically, this is on the maintainability.
Lord, subject to being corrected. But the question is one of whether the plaintiff got a right in terms of section 105 or not.
That is so. If they have not got a right under 105 to become your lessor,
my landlord,
your lessor,
yes, yes,
your lessor,
yes,
or the landlord by whatever name you
yes,
can call.
Yes.
So there cannot be any landlord-tenant relationship.
Very well.
So basically, this is the issue. Finding on this issue boils down to the issue of maintainability.
Yes, and then issue number 9
is what? Maintainable. All right. You can place only these 2 issues.
Yes.
Issue number 6, what is the finding?
My lord. Lord, kindly. Lord, comes to internal page 9.
Yes.
Lord, the second paragraph. In this case, learned advocate for the defendant argued that there was no relationship between the plaintiff.
So all the issues were taken together, 6 and 9. 6 is the landlord-tenant relationship.
Yes, both these are
9
taken
is
together.
the maintenance. So these were taken up together.
My lord.
Yes.
In this case, learned advocate for the defendant argued that there was no relationship between the plaintiff and the defendant as landlord and tenant, as the lease deed had no validity at that relevant point of time. Learned advocate for the plaintiff submitted that the lease deeds were valid and there was relationship of landlord and tenant between the plaintiff and the defendant. I have gone through the materials as well as the evidence of DW1. He has stated that they used to pay the rent to the plaintiff so and so since 1979. So I find that the DW1 has admitted the plaintiff.
Yes, so the finding is by virtue of these lease deeds and the rents deposited in the name of the plaintiff. So the trial court comes to the finding at page 11.
My lord.
I find from the challenge that the defendant has deposited rent to the rent controller. So considering the facts and circumstances, declined to hold that the city is maintainable, and there was relation. It should be I'm inclined to hold,
My lord.
not
My lord.
declined.
My lord.
So basically, these are the two reasons.
My lord.
Those two lease deeds and the rent control challans, which were produced to show that you have deposited rent before the rent controller in the name of the plaintiff.
My lord.
Yes. Now,
appeal court.
Appeal court.
On this issue, appeal court.
On this issue, appeal court. Yes.
Lord, kindly comes to the findings with reasons. We start at page 37.
Yes, 37.
37.
Yes.
Lord, kindly, my lord, give me one. Lord, kindly comes to Lord, page 41.
41, yes.
But I have mentioned, Lord, this is, Lord, the court is referring to our
Where?
Lord, page 41.
Oh, yes, stop. Yes, but I have mentioned earlier.
But I have mentioned earlier that in support of his competency, plaintiff filed and relied upon 3 documents, Exhibit 1, 2, and 3. But these are the 2 lease deeds
and the
letter of atonement in favor of
atonement. Yes.
Exhibit 1 and 2 are the registered lease deeds, whereas 3 is a letter dated 20th April 1989 of the owner so-and-so, confirming that the plaintiff to continue to receive rent from the tenant of the said premises and to file suits for the eviction of the tenant of the said premises. Pausing here for a moment, and to say that that establish the competency, the plaintiff learned counsel so-and-so, much emphasis over the contents of the letter, coupled with section 2D of the Act and contents of the lease deeds, quoting the very section, Mr. So-and-so, he draws attention as to the meaning of landlord. Then, Lord, kindly skips over, kindly comes to the Lord last 6 lines, starting with the words undoubtedly. Undoubtedly, from the reading of the terms and conditions of the lease, as well as the letter of so-and-so dated 20th April 1989, it is crystal clear that the present plaintiff so-and-so were given power to receive rent from the tenant of the said premises and to file suit for eviction of the tenant of the said premises. And Lord, kindly skip the word this. And there cannot be any doubt of competency of the plaintiff in this regard. And then the last 3 lines of the paragraph, I find no good ground to find otherwise. Point number so-and-so is answered in favor of the so-and-so. As point number 2 herein, I am to say that the materials, there are admissions on the part of the defendant regarding possession. But this is with regard to the subletting.
Yes.
Now,
basically affirming on these 3 documents, Exhibit 1, 2, and 3, those 2 lease deeds, letter of atonement, and also on the terms of the lease deed, it falls within the inclusive definition of the word landlord.
My lord, I shall come. My lord, kindly comes to page 44.
Yes.
So kindly sees the second paragraph starting with the words, as regards point number 3, I am also to say, Lord, these Lord are again not the ground number 3 or issue number 3. Lord, the learned first appellate court, Lord, formulated out of the 9 issues, he says that according to me, one issue is the locus standi, the other issue is subletting, and
basically 2 issues.
Yes. So
because one is maintainability of the suit.
Yes.
Wherein main issue is whether there is an landlord-tenant relationship or not.
Yes.
And the main ground is subletting. So these are basically the 2 issues which are relevant.
No, what my lord I indicate is when he says point number 3, it is not ground number 3. It is
it's not ground number 3. Yes.
As regards point number 3, I am to say that this is the only apple of discord. when possession is admitted to find out the case of subtenancy, the only further point that is required to be looked into is whether they were in exclusive possession or not. But kindly skip over and will not kindly come to the line starting about 3 lines thereafter. Learned counsel on behalf of the appellant.
Yes.
Argued much on this point, taking into consideration the fact of possession of persons named and stated that mere transfer of possession is not sufficient unless handing over of exclusive possession of the same or unless there is a consideration for delivery of possession. According to the appellant, they are in permissive occupier and the license.
Consideration, Mr. Chaturvedi, earlier line of decision says it's the onus lies upon the plaintiff to show that consideration was paid. Now,
no more good law. But exclusive possession, my lord, I say, my lord, this is where, my lord, I would address my lord, that the finding of the court with regard to exclusive possession is, my lord, perverse because there is nothing save and except, my lord, the stray statement in courts of evidence by PW1. Lord, kindly comes to page 47.
47.
47. Lord, kindly sees, Lord, the last 6 lines, starting with the word in this juncture.
Last
6 lines.
Yes, in this juncture.
I am to say that so and so, though made as a pro forma defendant in the original suit, but they did not appear to contest the same, though one of the authorities had come and adduced evidence, so and so, supporting the claim of the plaintiff. Well, I pause here for a moment. But if I am saying that the defendant number 2 is my landlord and he is a party to the proceeding, but he was the best defense, best evidence to be produced to say that no, he is in exclusive possession.
Could have called him.
Yes, now.
Could have called
yes,
him.
now.
Because
PW, I address. PW3, Lord, one person came saying that I look after the affairs of the defendant number 2. I look after the affairs of defendant number 2. But the probability of the value, where he is cross-examined, I shall show. Sir, 2 years. Lord, God has given 2 years. One to hears that something that comes from the front and the other one from the sides.
So you have a ear in the front also. Both sides to hear Mr. Banerjee and Mr. Bose on both sides.
And the hearing from the right should be ignored.
Yes, yes, Mr. Chaudhary.
Now, Milord, page 48, Milord, the mean profit is declined.
Need not go into that.
Right. So, kindly see, Milord, insofar as what I have raised in paragraph 14 and 20 of my written statement, that until and unless there was a transfer in terms of section 54 of the Transfer of Property Act, the right to sue cannot be conveyed by a letter. Second, bereft of possession, 1979 or 1985 lease, they do not convey anything. That strikes at the very root of the status of the plaintiff to institute the suit. Lord, I directly, Lord, come to Lord, the proposition of law on this. If Lord, I succeed on that, then I need
that
not.
Is your best point, Mr. Chaturvedi.
My lord.
If you can
Then I
succeed
need
on
not.
that, you succeed on that, or I will allow you to then canvass the second point.
My lord. And if I succeed on that, then
so I will
say,
proceed in part. I will hear you on your best point. I will hear Mr. Bose on in reply to your best point. Then I will hear the other point.
My lord. And if, my lord, it is decided on this
in your favor in the first point, no use going back to the second.
Yes, yes. I'm saying that if it is decided on this question of law itself, it would be a classic case of a second appeal being adjudicated.
Let's see.
Because I then would have no reason to invite my lord to the evidence or the exhibits at all.
Yes, looking at the points you have taken and the question on which it was admitted.
My lord.
Yes, you want to show the Transfer of Property Act first?
Yes.
Transfer of Property Act. দিয়েছেন না? ওইখানে ঢুকে গেছে। ঠিক আছে। Yes.
Lord, kindly sees, Lord. Lord, section 105.
Yes.
Lord, what is sine qua non?
Transfer of a right to enjoy the property.
Yes. And on the date the property is created, admitted position is,
according to your, the sum and substantive of your argument will be that as on the date of execution of the deed of lease, the defendant number 2 did not have the power or did not have the right to enjoy or possess. If that is so, he could not have transferred that right, because lease is not transfer of an ownership, it's only transfer of a right to enjoy. So basically, a person who does not possess a particular right cannot transfer the right to another. So if on a particular day, the lessor, the original lessor, did not have the right to enjoy on his own, could not have transferred it to any other person. Here, the plaintiff. That's the summary.
I'm grateful to my
of your argument on
My-
section 105.
my-
Yes, next.
Lord, kindly on this issue. Lord, kindly sees, Lord, this is a decision, Lord, reported in Lord. Lord, this is, Lord, reported in AIR 2005 Calcutta 281. Kindly permit me, Lord.
AIR
2005 Calcutta 281. Let me have the privilege of,
portions which are in favor of you or against you.
no, let me have the privilege. Let me have the privilege of apologizing.
Yes, yes.
Lord, kindly sees,
But Mr. Banerjee, it's Monupatro. It's correct.
Lord,
We dealt with mistake, typographical, punctuation.
All right, place it. You are also placing from Monupatro
My lord.
or SCC online.
No, Lord. And Lord, the time.
Here, advocates are not using SCC
No,
online.
no, SCC online I am using.
So-
Only thing is that, Lord, if I have been put, Lord, with my.
Mr. Bose, please check it. if there is any.
First held about এক মিনিট বেরিয়ে
Yeah, 2005 Calcutta 281.
আরে এ তো ভাস্কর ভট্টাচার্য জাজমেন্ট মানে this has been set aside in the Supreme Court.
I shall address. I shall address.
ভাস্কর ভট্টাচার্য জাজমেন্ট সোমনাথ মিত্র I have it.
Yes, yes, Mr. Chudu.
No, Lord,
Yes.
Lord, this is,
আমি AIR টা দিলাম
ঠিক আছে, কোনো অসুবিধা নেই।
Oh, this is a 2005.
Yes.
So where is that decision which has been set aside?
This is the decision which was set aside by the Supreme Court. I'll give you a lordship. This is
I shall show me. I shall show.
All right.
I shall show.
2015.
Mr. Chaturvedi, you can place.
Yes. This is, Lord, a case in
This
respect.
is AIR online, Mr. Bose. The copy which you have given from AIR
Yes,
online.
yes.
Mr.
No,
Bose, you can,
SCC online, but this is the true print.
not SCC online, AIR online it says.
AIR online. Very well, AIR. And my lord, this was set aside by the Supreme Court in the judgment reported in 2015, volume 15, Supreme Court cases, page 567.
I shall show that.
Page
567.
567. All right. So
Same suit property, other tenant in respect of the same suit property.
yes, Mr. Chaudhary.
I shall show, my lord, the judgment set aside.
All right,
It was
yes.
sent on remand and then it has been disposed. I shall show all the judgments.
Yes.
Lord, this is in respect of a suit being instituted by the self-same plaintiff in respect of a property in the same premises. Same premises. Identical, my lord, facts, point, my lord, of law, which, my lord, I raised before my lord, are dealt with here. Lord, kindly sees paragraph 17. Lord, there are, Lord, three suits, Lord, were dealt together. We are at the moment concerned with, Lord, title suit 347 of 1997, a reference of which my lord would find at paragraph 5.
Yes.
Lord, permit me to place paragraph 5. Title suit 347 of 1997, on the other hand, was filed by so-and-so, the defendant number 1 in so-and-so, against the appellant number so-and-so, as also so-and-so, thereby praying for a decree of khas possession of portion of the suit property from so-and-so. In the said prayer for mean profit was also made. Emerald so-and-so, admitted owner of the building, and the other heirs and legal representatives were made pro forma defendants in the suit. The identical situation, Lord, kindly now comes to paragraph 17. So far as the decree passed in title suit 347 of 97 is concerned, the learned counsel challenging the decree have vehemently contended that even on the basis of averments made in the plaint of so-and-so, the suit was not maintainable. They point out that so-and-so, the plaintiff herein, has claimed that by virtue of lease deeds executed by so-and-so, the admitted owner of the building, it has been given right to realize future rent from the tenant and to file suit for eviction against those tenants. And on the basis of such right, the plaintiff filed the aforesaid title suit number so-and-so. According to them, once the property is in possession of a tenant or a lessee, the landlord of the premises cannot execute another lease deed in favor of the third party over the self-same property for the purpose of mere realization of the rent from the existing tenant when the lessor is unable to give actual possession.
Paragraph 33 is the answer. Oh, sorry, you are on another copy. 33 would be.
So you can refer 33 from here. That is the same copy.
You have not marked for me. That is the whole difficulty. I don't find my markings in your copy. But thank you.
33, same paragraph.
33.
Telling.
My lord.
You can come straight away to paragraph 33 of your judgment.
My lord. Therefore, we are of the view that the lessor can create a third party's interest in the leasehold property either by creating sale deed in terms of section 54 or deed of exchange conveying lessor's right or making gift or creating mortgage, but having himself divested of the right of enjoyment of the property and reserving only lessor's right. The lessor cannot further create any lease. Lease is a peculiar doctrine of separation of title and possession. On execution of lease, the title remains with the lessor, but the possession goes to the lessee. And once such document is executed, the lessor is capable of only transferring his title to the property by executing deed of sale, exchange, mortgage, or gift, but cannot transfer the right of enjoyment over again, as he is already divested of such right at the time of creating of the first lease.
Then relies on a single bench judgment. The author is the judge who delivered this judgment.
Yes.
The division bench.
Yes. I have
2002 volume 2.
I have brought that judgment also, my lord, because of the language.
That was on order 22 rule 10.
Yes.
That was on order 22 rule 10, whether it can be substituted in the suit. Yes. So 33 is the answer which you are trying to
My
show.
lord. My lord. And Lord, kindly, Lord, comes to paragraph
That's the same.
Yes.
Firstly, 79, because that was the basic right on which it was.
Lord, kindly comes to paragraph 54.
54 of your judgment.
Yes. But I believe since the paragraphs are telling, all should tally, but may I check?
Let me check. 54 is we thus set aside the judgment and decree.
Yes. We thus set aside the judgment and decree passed in the title suit so and so and remand the matter back to the learned trial court for permitting the plaintiff to amend the plaint by adding so and so.
Yes.
Now, Lord, an SLP was preferred against Lord, this judgment. No.
Lord, I have the direct Supreme Court copy if your lordship takes this. From the
You have one more copy
original
so that you
website
can give it to Mr.
Yes, yes,
Chaturvedi.
I'll give it to Mr. Chaturvedi.
Yeah. Lord, kindly sees Lord, the third paragraph. Upon hearing the learned counsel for the parties, we are of the view that the High Court
because only on the constraint one of the parties to amend the plaint.
Yes.
On that ground, it was set aside.
So only on that technical ground, Lord, it was set aside. Thank you. Now, Lord,
So
kindly.
it was set aside and it was remanded to the High Court.
Yes.
Yes. Then what happened?
Lord, kindly permit me, Lord, to pause here for a moment. In the meantime, Lord, our courts, Lord, have taken notice, division bench, taken notice of the proposition of law laid down in this. Argument was made that the decision has been set aside. But the court said that when the decision is set aside on technical grounds, the ratio decidendi still continues to hold water.
No, Mr. Chaturvedi, what happened after this was set aside by the Supreme Court? What happened in this matter?
The appeals were disposed of on the basis of a consent order.
We got back possession. As simple as
no consent order.
No.
Is,
Lord,
so
it was
issues
the
were not decided.
No, not decided. It was the appeal of the tenants.
Yes.
So they withdrew the appeal. There was a terms filed. They
Suppose one thing is
My
that the issues have not been decided. The issue here is with regard to the maintainability.
Right.
Now the maintainability was decided in one way by the division bench, carried before the Supreme Court.
My lord.
Now there it was set aside.
Right.
Yes, you may say that yes, that judgment has already been set aside.
Set aside.
Now, but the issue
Remains undecided.
remains undecided. Issue remains undecided.
My lord, your lordship will also need to, my lord, when the matter came on remand, my lord, we were conscious of this fact. So, my lord, this is the judgment which was delivered upon remand and post the settlement between the parties, because they said that we want to vacate on certain terms, but we insisted that the issue having been remained undecided, what needs to be done? My lord, kindly have a look at this judgment of the division bench.
Yes, yes, I'm showing that. I'm showing that. দাও তোমার কপিটা দাও।
You have a copy of this?
Yes, yes. Yes.
দেখুন এখানে।
Yes, yes. আছে, আছে।
Yes.
Thank you.
Well, if your lordship kindly takes internal page 5.
Yes.
Three appeals were preferred, the paragraph immediately thereafter. In the appeals, it was contended that KCL, my lord, which was the plaintiff and the present respondent here, was not entitled to claim itself as a landlord since no physical possession of any portion was given to it in 1979. It is pertinent to note that On that basis, the appeals had been carried, disposed of by an order of 1st April 2005. Now, this is the division bench order. But the same was set aside by the Supreme Court after contested hearing by its order of such and such, and the appeals were remanded for fresh hearing. Inasmuch as KCL had been inducted by a registered lease of 9th May 1979, the question of physical possession of the property being further handed over to KCL was not essential requirement under Section 107 of the Transfer Property Act. Moreover, at all material times, the tenancy in question was attorneyed in favor of Khaitan Consultants by the tenant, who even paid rent to KCL, in any event by seeking a declaration that the appellants are a tenant under KCL. They have admitted the right of KCL. Further, according to KCL, after the Premises Tenancy Act 97 come into force, the right of a tenant is subject to the definition of tenant under 2G. But this is the other point. This was the other point.
2G.
No, that's
But
the
now
other
the
point.
Supreme Court
No,
has
I'm not on 2G.
taken
I'm
a
not.
different view.
That's in my matter again.
1978 death. No.
No,
it
no,
will be a tenancy under the old act. 2G.
No,
will
no,
not
no,
apply.
Lordship will not get influenced by 2G.
From
Before
its
2G.
window,
Till
because
before
that's the-
2G.
That's the finding on which it was held that you are no longer a tenant.
No, if your Lordship will see.
Trespasser.
No, prior to 2G, the sentence starting, that was a paragraph that ended. Further, the paragraph before further, that was a separate issue altogether.
Page.
My lord, paragraph 5,
No,
where it
paragraph
ends.
number is here.
No, my lord, page 5,
Yes,
internal
page
page 5, where it ends. If your Lordship turns to the next page,
By seeking a declaration.
they have admitted the right of KCL, it stops. Then there is a separate paragraph which deals with 2G. So what my respectful submission is that the issue whether KCL could maintain an eviction proceeding based on the registered lease of 1979 without possession having been handed over.
These issues, Mr. Bose, were not decided.
But this is what the division bench recorded.
No, division bench may have been.
Yes.
Ratio.
Yes.
Issue that was decided, held, and that decision relies upon a Privy Council judgment.
It does. No, my lord, not just the Privy Council judgments.
That is there.
There are several other judgments also which the division bench did not take into consideration.
Which division bench?
There are several other judgments.
Those were prior. Those were subsequent, did not take into consideration the Privy Council judgments.
No, if your Lordship is talking about the division bench of Justice Bhattacharya.
Justice Bhattacharya relied upon a judgment of a Privy Council.
Yes.
That has not been set aside.
No, it's not been set aside.
Same issue.
Our issue
basically relies upon.
Yes.
If you come to the decision of Shambhunath Mitra.
Yes.
Please kindly come to paragraph 30.
Yes. I am at 30.
There were two division bench judgments also taking a contrary view. Paragraph 30.
Yes.
The decision of the division bench in the case of Jawaharlal Bhutra 1922 Cal is no longer a good law in view of the subsequent decision of the Privy Council in such and such. Similarly, the subsequent decision of the division bench in the case of Sri Narayan such and such cannot be treated to be a valid binding precedent, as the division bench failed to take note of the earlier existing Privy Council decision. Privy Council decision has been quoted in paragraph 31. That proposition of law has been considered. That was only followed in Shambhunath Mitra versus Khaitan Consultants.
My lord, your Lordship will see.
Independent finding on that. That was followed. That was applied to the facts of this case. And in this judgment, after remand, that issue was not decided.
These Privy Council, this was our specific point before the Supreme Court. Thus, these Privy Council judgments and the judgments which were there on this point does not remotely suggest what has been held by the division bench.
But on that ground, it was not set aside. It was set aside only on the ground of
now I take 10 grounds. I take 10 grounds. Supreme Court sets aside it on one ground. So what do I do?
Mr. Bose, I follow that Shambhunath Mitra versus Khaitan Consultant 2005 Calcutta was set aside.
Yes.
But Privy Council.
No, of course, we'll deal with that. Of course, we'll deal with that.
And in this judgment, that issue,
Yes.
whether in view
Yes.
of the fact, because
Yes.
105, Mr. Bose,
Yes.
is the right to enjoy.
Yes.
And that's the lease. It's
Yes.
a transfer of the right to enjoy.
Absolutely.
So if a particular basic thing, you need not also go to 105.
Yes.
If you do not have anything,
Hmm.
can you transfer it to someone else?
No, then there will be another question, my lord. Another issue will be that. Yes.
Ownership is a bundle of rights.
Yes.
Of which one of such right is the right to possess.
Yes.
Which has been transferred by way of a lease.
Yes.
So if a right is transferred by the owner, so that right he does not have at that point of time to possess.
Yes.
So if that is not there,
yes,
whether that person can transfer that right to possess to another person.
No, possess, my lord, if your lordship will see the terms of the lease, the terms of the lease is very clear. The right that he had to evict, he had a right to evict as well. No, the original landlord, defendant number 2.
Cannot be, because that goes to the possession.
Yeah.
Right to evict
Yes.
goes to the possession.
No, my lord,
So
today,
he could have.
but there will be a more fundamental question to this, that whether after having accepted me as the landlord, whether he would fall under the exception to 116 or not.
Derivative type.
No, that's what I'm saying. To what extent?
You could have.
My lord, I'll show your lordship a privy council.
Mere deposit of an amount.
Yes.
Before the rent controller does not decide the.
This is not a, my lord, this is a situation where he has continued to accept me. Atonement was accepted. He was accepted me as a landlord. He continued till notice under section 13(6) was given. This was his stand post the notice under section 13(6). So whether he comes within the exception to 116, also your lordship needs to consider. Yes.
If the lease do not confer, could not have conferred any right upon you.
Yes.
Everything goes.
No,
For
my lord.
everything, right to collect, everything, right to evict, right to file flows from that lease.
So now, my lord, your lordship will see that then there are two issues then. One is whether he, under the given facts, could have taken or could have challenged my title, or whether 116 is a bar or not. And if it is a bar, to what extent is it a bar?
Could have been, it could have been stopped, provided you are the inducting landlord. It's not that.
No, my lord,
You are
even
not the
if
inducting landlord.
no,
and your predecessor was also not the inducting landlord.
Where has he made out that
Predecessor
case?
was not the inducting landlord.
Yes, he was the inductee. That's his case.
He is
Subject to correction.
From 1923. Your predecessor was also not the inducting landlord. Your predecessor also had the derivative title. He is from 1923 from someone else. From that, it was transferred to defendant number 2. So your predecessor was also not the person who has inducted him.
So that means,
Made out by him,
so that means,
decided by either of the courts below.
no, my lord, the question is that whether this,
116,
yes,
subject to correction by you,
yes,
be applicable.
very well, very well. We will satisfy. We have understood, my lord, this is the issue, and this is the, in fact, if your lordship will see the substantial question of law, this is the only substantial question of law which has been framed. So we'll address that. Let my learned friend
address it. Mr. Bose, no adjournment.
No, adjournment. There's no matter. If he finishes, I'll.
Yes. He has finished. Please. Anything more, Mr.
Yes.
Chaturvedi?
Milord, insofar as Shambhunath Mitra is concerned, after, Milord, it was set aside. Milord, an issue cropped up before a division bench, Milord, of this honorable court, where Shambhunath Mitra, Milord, was sought to be relied. Milord, an objection was taken that this judge
set aside.
That has been set aside. Milord, kindly see, Milord, the observation of the honorable division bench.
Please give a copy to Mr. Bose.
Yes. Yeah, copy that.
Which was set aside?
Shambhunath Mitra set aside by Supreme Court, but sought to be relied upon. What did the coordinate division bench say? Milord, kindly see, Milord, paragraph 54. Yes. 55. Without determination, I'm sorry.
55.
55.
Oh, paragraph 55, sorry.
Paragraph 55. The fact in issue, Milord, is in paragraph 55.
Yes.
Without determination of the tenancy or lease, no subsequent tenancy or lease could have been granted to a subsequent tenant lessee in respect of self-same suit property. Right to future rent is a right in immovable property, and if such right is transferred in favor of third person, such transfer must be effected in accordance with the provision of sale contained in section 54 of the Transfer Property Act. In other words, a right to realize future rent and profit from an immovable property can be created only in accordance with the provisions contained in section 54 of the Transfer Property Act, meaning thereby by sale. Now, Lord kindly Lord turns to paragraph 56.
Yeah, I'm at paragraph 56.
Lord,
Yes, yes.
Lord, Mula was cited, and
Yes.
then paragraph 50.
5-6 lines in view of the law settled by the Privy Council.
My lord. And then 58. Lord Khaitan
7 considers the expression any of his interest therein.
My lord. And then 58, Lord, the Supreme Court decision in Khaitan Consultants, my lord, handed up to my lord. This was, my lord, sought to be, my lord, and then 59,
Yes.
only to the extent stated above, the judgment of a coordinate bench of this court in Shambhunath Mitro was set aside, and the concerned party was granted liberty to seek permission to amend the plaint before this court. Thus, the ratio decidendi, except to the extent that observed by the Honorable Supreme Court mentioned above, still is a good law and holds a field on the issue of concurrent lease. And then 60, my lord, again Shambhunath Mitro, my lord, the ratio, my lord, is.
So now, with regard to that lease part, the division bench says that it still holds good.
My lord. And there is no, my lord, SLP against this, my lord, to my understanding. My lord, there are, my lord, some
And
other.
by the same composition.
My lord, composition, my lord, one decision.
No,
The
the
honorable.
same composition.
This one is not by the. This is not by the same composition. This is 2018. I indicated to my lord.
No. The
Presiding say.
presiding is same.
Lord, 2022, which I indicated to my lord.
Uh,
The last one which I showed to my lord.
That is the division bench judgment in Khaitan Consultant matters before the division bench.
My lord. Yes,
The
yes.
composition is not the composition. The one of the author of the judgment is same.
Now 2000.
Composition is different, but the author is same.
2022. 2022 is by Justice I.P. Mukherjee.
Yes, the other one is also by the same
Shambhunath Mitro.
Shambhunath Mitro ultimate final order. Final order is also.
Yes. My lord, kindly, my lord, permits me, my lord, to cite, my lord, this is 2005 SCC Online Calcutta 373. This.
Yes.
Okay. 2005 SCC Online Calcutta 373. A cross citation 2006 volume 1 CHN 12. But the facts are in paragraph 12. Paragraph 2.
For what proposition?
Milord, identical. And Milord, kindly sees, Milord, paragraph 12 to 15 is a decision.
So according to you, this issue or the finding on this issue is binding, even if that judgment was set aside by the.
In view of the division bench judgment.
Paragraph 12.
Milord, paragraph 12 to 15. Milord, kindly sees 13, the last 3 lines. Or 4 lines, over the suit property in occupation of the defendant. The
Yes,
plaintiff.
no, lawful tenant was created in favor of the plaintiff in respect of the property occupied by the defendant number 1.
My lord.
Once it is held that by virtue of the tenancy became tenant by dint of the right. Yes.
And then paragraph 20, the suit was dismissed.
Yes.
Lord,
anything more, Mr. Chaturvedi?
Lord, another Lord decision. Lord, this is reported in 2007 SCC Online Calcutta, page 628. But paragraph 45 to 49.
On what point?
But same point, and Somunath Mitra, my lord, has been. So I say the issue is no more res integra. My lord, the
Paragraphs
45 to 49.
No, but this was prior to the Supreme Court in Khaitan Consultants.
I say, Lord, Somunath Mitra and the decisions prior to the
So
Supreme
your
Court.
answer to Mr. Bose's submission that it was set aside is the decision of 2022.
My lord.
That law still holds good.
The
Even if
ratio
it was set
decidendi.
aside one technical ground.
My lord.
Anything more?
Not only this.
I hear Mr. Bose on this technical point, then I will hear both of you on that subletting. Yes.
No, my lord, this is the principal point. What, my lord, whether to what extent, my lord, he can challenge, and my lord, the judgment of the division bench of Justice Bhaskar Bhattacharya. And my lord, whether there is any other law, because if your lordship looks at the 2022 judgment which has just been handed over,
Yes.
my lord, there are judgments which says otherwise. My lord, if your lordship will first, your lordship has to see the two judgments of the Privy Council which has been referred in the division bench judgment in 2021. In 2005 Calcutta 281.
Yes. That was also considered in this judgment.
But that
36 Privy Council.
Yes, Amy Mullah.
Yes, that was considered, and it was been said that that law still holds good. You can straight away come to paragraph 50 of that decision. Is still holding the field on the subject of concurrent lease, deciding the same to be invalid.
I think your lordship is referring to para 58.
50 of this the 2022 judgment. 50
of Justice the division bench of Justice Mukherjee.
Yes.
I have the server copy.
Oh, paragraphs not telling. So this is also, I think, of the server copy.
Yes, we gave it to you.
No, so if your lordship takes para 58.
No, I said paragraph 50. 50.
Yes.
6-7 lines from the bottom of that paragraph. In the matter of Amy Mullah Sons Limited.
Yes.
Is still holding the field on the subject of concurrent lease.
Yes. Deciding the same.
Yes.
To be invalid. The said decision was not considered in any of the judgments relied upon by the Learned
And
Council.
thereafter, the effect of the Supreme Court judgment of setting aside Khaitan Consultant, that was considered.
Yeah, that is at para 58.
Yes, that is at para 58.
It says
but
that
the law, because Khaitan Consult, Somunath Mitra, in that matter, Mr. Bose,
yes,
that Amy Mullah was followed.
Yes.
The law laid down in Amy Mullah was followed.
Yes.
So now, here also, Amy Mullah has been followed, and the effect of setting aside has been considered.
Correct.
In paragraph 58.
Yes.
Thus, the ratio decidendi, except to the extent as observed by the, still is a good law and hold the field on the issue of concurrent lease. So here it holds that the finding on the issue of concurrent lease in Somunath Mitra, which has been set aside, that finding on that issue still holds good. If that is so, more so, Mr. Bose,
yes,
in this, it's binding upon you. Identical facts, a different view cannot be taken. Because facts are identical in the case of this Khaitan Consultants. Different case.
No, so far as my right to sue.
On the same facts.
Yes.
And it has been held, yes, that decision on that subsequent lease or the concurrent lease.
Yes.
That Khaitan Consultant, that issue still holds good. Where it has been held, no, it's bad.
So it says, does the ratio, except to the extent as observed by the Honorable Supreme Court mentioned above, still is good law? Yes.
But the decision on that issue still holds good. And 36 Privy Council also has been said.
No, but how does it hold good? I'm not been able to understand this, my lord. If a judgment is being set aside,
that I do not know. Mr. Bose, I cannot comment on that. How it holds good, Mr. Bose, it's binding upon me.
no, my lord, a coordinate bench can
I'm not a coordinate.
follow the no. This is of course by submission. A coordinate bench can follow the same, follow the same analogy, follow the same reasonings, and give a judgment.
No, it says same. It's still holding the field. That decision is still holding the field.
How is it holding the field, my lord? Look at my lord, the language of the Supreme Court. The judgment is set aside.
Mr. Bose, I cannot comment. I cannot say that it's not binding upon me. You may say many things from there,
No,
but it's binding upon me.
No, my lord, I'll tell you, lordship, my lord, why I am saying this.
You may argue.
Yes,
you
of
may
course,
say many
of course,
things,
of
but it's binding upon me.
No, my lord, this finding of the division bench with respect, my lord, that the ratio of in Shambhunath Mitro,
I cannot
that it was only set aside only to that extent, and the still is good law. In my respectful submission, my lord, this cannot be, my lord. I can give you, lordship, several judgments. In fact, we have argued one, my lord. There was on a completely technical point, the Supreme Court was set aside the appeal, and there was no remand. There was no remand at all. It was just set aside. Of course, it was on a different proposition of law. So that judgment.
Yes, this setting aside was on a very limited ground, Mr. Bose.
My lord, it was on a limited ground, but the fact remains it was set aside.
Yes, because only amendment part. Because
now, my lord, I take
Mr. In that it remanded to the trial court.
Correct.
It remanded to the trial court, giving liberty to amend.
Right.
That liberty was taken away. It means it was restored to the first appellate court to decide as it is.
Yes. So it was a decision de novo.
Yes, to decide as it is.
Yes.
And it was, yes, you are in a way right.
No, my
that
lord,
the entire decision goes.
Well, I'll tell you, lordship, my lord,
Maybe
why
on
am
technical ground.
my lord, allow me to address this. My lord, kindly take the judgment. After remand, the judgment that came, it was that same division bench. Division bench could have said the same thing. That the ratio.
That, Mr. Bose, I cannot
No,
say
my lord, I'll tell you, lordship, my lord,
what the division bench could have said, Mr. Bose.
my lord, your lordship can take judicial notice of what I submit. And then, my lord, your lordship will decide. I'll tell your lordship why.
What is the date of this judgment? This Khoitan consultant judgment after remand.
After remand, I'll give you.
Remand from the Supreme Court.
Yes, I'll give you, lordship, the date. The date is, after remand date is 14th of June 2024.
Yes.
And this one, that one we are looking at.
It was a consent, Mr. Bose. No issues were decided.
22. This is 22.
No issues were decided first. Second is, it also took into consideration because that concurrently is anything that was not considered. Secondly, it proceeded on the basis of 2G, which is again
2G was a.
Which is again that was also one of the grounds. That was also one of the grounds.
No, it wasn't.
Yes, yes. Please see.
No, that was not a ground at that relevant point of time. It says further.
Now you
further
have no right.
now.
But now the Supreme Court, Ramesh Mitro, is difficult. It says
review is pending, my lord. It was me.
It was the tenant under that.
My lord, I was the tenant before the division bench in Calcutta High Court. It was the division bench of Justice Harish Tandon. My lord, Justice Harish Tandon said no. In any way, let's not decide these issues because you are hit by 2G. In any way, you have to go. So you go now. So 2G was held against me. So when it went to the Supreme Court,
same thing happened to me also.
And but there is a
different bench.
Yeah, review is pending.
But there was an observation.
Yes.
After my argument, there was an observation that there is a necessity to amend the statute. That was the observation by the Honorable Division Bench, presided over by Justice Banerjee.
Nasima Naki. No, my lord.
So after that Supreme Court, now same point was there. Now, what happened is subsequently the
So, of course, my lord, we are extremely hopeful. So far as the Rajesh Mitra judgment is concerned, review is pending. And there are my lord, 3 direct Supreme Court judgments. My lord, 2 from Bombay Rent Act, which says absolutely otherwise. How can it even say that the legislature does not have the power to restrict rights? The legislative intent is clear. The rights of a tenant have been restricted.
law as it stands is Ramesh Mitra is still holding the
Yes, yes, of course, of course.
still holding the
No, my
field. We do not know what will happen in the review or other things. So this was one of the grounds, and the fact remains that here that issue of concurrent lease was not
I'll
decided.
tell you, Your Lordship.
It
but
was a
kind-
consent order giving. So
No,
it
no,
was not
no.
decided.
Apart from the consent order, Your Lordship will kindly consider this. This, Your Lordship is looking at the same division bench of 2022.
Yes, yes.
Now, my lord, take the 24. Post remand, the final order. Kindly take that
Yes,
once.
yes.
My lord, is it a order on remand? My lord, kindly have a look at this. Kindly see this. Such and such, appearing such and such, handed over court
Placing Mr. Bose.
from the first paragraph of the 2024 order. This is the 2024 subsequent.
Yes.
Appearing such and such, handed.
2024.
Yes, 14th of June 2024.
Yes.
We have carefully perused the draft order, also examined by such and such, appearing for the appellant. On our part, we endorse the suggested order and we set it out below. So, not only the portion has been set out, then, my lord, your lordship will kindly, I'll tell your lordship where the set out ends. My lord, if your lordship kindly takes. Now, my lord, kindly take paragraph 4, internal page 4, I stand
Yes,
correct.
yes.
In the said judgment, the learned judge rejected the contention raised by Shulotade and dismissed her suit, holding that the tenancy of such and such to transfer to PC there. My lord, now kindly take the bottom of internal page 4. It was categorically held that KCL had been inducted as a lessee in the premises under the registered lease of 1979. And after surrender, the tenancy of Prashantotanda Dev was entitled to vacant possession. Thereafter, 3 appeals were carried from the said decree. The 3rd appeal was dismissed as not pressed then. In the appeals, it was contended that KCL was not entitled to claim itself as a landlord since no physical possession of any portion was given to it in 1979. It is pertinent to note that on that basis, the appeals had been earlier disposed of by the order of 1st April 2005, but the same was set aside by the Honorable Supreme Court of India after a contested hearing by its order of such and such, and the appeals were remanded for fresh hearing. Inasmuch as KCL had been inducted by a registered lease of 9th May 1979, the question of physical possession of the property being further handed over to KCL was not essential requirement under section 107 of the Transfer Property Act. Moreover, at all material times, the tenancy in question was atoned in favor of Khaitan Consultants by the tenant, who even paid rent to KCL, in any event by seeking a declaration that the appellants are a tenant under KCL. They have admitted the right of KCL. Well, there was a 2 suits were there.
So here is the distinctive feature. There are suit for declaration
Yes.
of tenant under KCL was filed.
Yes.
So they could not have challenged the title or the right of KCL
Correct.
to evict.
Yes.
There lies the distinction.
No, would that be the only distinction?
Because admission.
No, of course. Here there is also admission. This is what I have to tell your lordship and show your lordship from the records.
They are challenging all throughout from
Where?
the reply to the notice. in
Yes,
the
yes, yes.
statement, they are denying that you are his landlord.
No, my lord,
Here,
on the
they have
notice.
filed a suit for declaration. They have, in this case, they have not filed a suit for
No, they haven't. They haven't.
So that was taken to be an admission, because they cannot say that having filed a suit, praying for declaration, they cannot say that we are not the tenant.
Now, my lord, your lordship has to consider. My lord, I will show your lordship. Here the admissions are to the extent that one is letter of atonement, number two, terms of the lease, number three, the fact that I have.
What is the letter of atonement, Mr. Bose? What is the effect of the letter of atonement? Where is the provision to serve a letter of atonement?
My lord, letter of atonement.
A letter of atonement is issued for what purpose?
My lord, if your lordship will see, my lord, when there is a transfer, when there is a transfer, my lord, transfer of right in a property.
So, atonement is basically when the property is transferred. Mr. X, let us suppose, was the original owner. Under him, Y was the tenant.
Right.
Now, X transfers it to A. Now, this fact, now A is being substituted in the place of X. He has a right to recover or to realize further rent. That necessitates the issuance of the letter of atonement. He is atoning his rights in the property to him, asking the tenant to pay future rents, or maybe if that deed, purchased deed, contains the right to recover the past rents, even that can be realized. And if that right is not given, that also cannot be realized.
Very well.
So that's the purpose of atonement.
Right.
So here is a case
Yes.
where the ownership may be transferred, that has not been transferred. Right to enjoy could not have been transferred. What is the effect of atonement? For what purpose?
So what was transferred and what was accepted by them was the transfer of acceptance of rent.
Acceptance
My
comes
lord, yes.
after.
Very well. I'll address what was transferred. Let us first examine what was transferred.
Where is the lease deed?
No, my
Or
lord,
where are the
yes,
lease
yes.
deeds?
Well, the lease deed are at. If your lordship will take our
compilation, its lease deeds are there.
No, no. Yes, there is there. দুটো lease deed আছে তো। My lord, I have a list of exhibits.
You have a document?
Yes, yes. I'll hand
give me
over.
a document.
My lord, we don't have extra copies.
Don't have one extra copy, at least for the court. Mr. Chaturvedi, do you have the copies of those lease deeds? You don't have the copies of the lease deeds, exhibited documents, Mr. Chaturvedi, in a second appeal. And that's the basic document.
On the other day, my lord, when I was saying that I need to have, my lord, copies of the documents.
Yes, Mr. Bose. Yes. Make your submission. Yes.
My lord, this is the registered lease of 9th May 1979.
Can you give me once? Let
Yes,
me
ma'am.
hurriedly
Of
go
course,
through
of
the
course,
lease deeds. I will give it to you.
Of course, ma'am.
To make arguments then.
We'll make copies for your lordship. But we also got it with great difficulty from the learned lawyer who
But
was
urgency,
conducting.
Mr. Bose, your junior mentioned on the very first day.
Yes, yes.
And this is the earliest day which I have kept.
Yes,
Second
absolutely.
day I have kept, and I could have kept immediately on the next day. But
Of course, yes, absolutely,
now-
absolutely. But we have, I think, 2 more months.
that is Mr. Bose.
We do. I think Supreme Court said 3 months. So we are just,
More than
we
1
haven't.
month has elapsed when it was brought to my notice. It was
When was the
6th
order
of
passed?
October. It was brought to my notice on 10th of November.
And the
More than
order
2
was
months
of 6th
has
of
elapsed
October.
when it was brought to my notice. So this is the first one, is the subsequent. No, 79 first.
This is the 79 original. The first lease, first register.
Now, this lease was in respect of the entire property.
Yes, entire building.
Entire building. Now, Lease rent was also for the entire building. But no lease rent could not have been claimed in respect of the portion which has already been given to Mr. Chaturvedi's client. Because that portion, what is the purpose of lease rent? For giving you the right to enjoy. So without getting possession, you cannot be saddled with the liability of rent, at least for the portion where Mr. Chaturvedi is in possession.
No, so he is saddled with the liability to pay rent.
Yes, but
So
here it
his
says
liability, there's no
here
shift
it
of
does
his
not
liability.
exclude that portion, Mr. Bose.
So why?
It's the lease rent for the entirety building.
Yes.
So it could not have been done. So it's inclusive of his portion.
So your lordship, then we are going back to that concurrent lease theory. That one lease already or that one tenancy is already in subsistence.
I'm also not on the, because the right to enjoy, Mr. Bose, you have to pay.
Yes.
The concept of lease, I'm not also on the concept of concurrent lease. The you have to, the lessee has to pay a consideration to enjoy, for enjoyment of a property.
Right.
So if you cannot enjoy a property, can it be saddled with the liability to pay rent? Let us forget for the moment Mr. Chaturvedi's liability. I'm asking your liability without getting a right to enjoy. Consideration is for the right which you have been given.
No matter right to enjoy would also include the right, my lord, to bring an action for eviction, get possession, and then enjoy. If your lordship will see, enjoyment right under the Transfer of Property Act, my lord, cannot be circumscribed only to physical possession.
Yes.
No, it cannot
What
be, my
is
lord,
lease?
restricted.
Mr.
That would be
Mr. Bose, what is lease? How you will enjoy? How you will enjoy? The right to possess, right to enjoy,
and right
not
to
the
right
right
to
possess
enjoy
into
other
the-
benefits, my lord, other benefits. So I am
What
been
are the
given
other benefits?
I have been giving the right to collect rent from the existing tenants. So that is my right, which has been by the lease, what has been given to me is a right to enjoy the usufructs of the property. That is, that is well within the scope of enjoyment.
And where is the next deed is the subsequent document. Next
Yes,
deed.
yes, 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 yes. Do you have the Privy Council? Any Mullah, 36 Privy Council?
Yes. Yes, Mr. Bose, you can take. You can now make your submission. এটা দিয়ে দিন তো।
My lord, I would like to show your lordship a few clauses from the first 1979 lease ones.
Yes, you can place the clauses.
Yes, yes, some relevant clauses, my lord.
Two rights you have been given: right to collect rents and right to institute suits for eviction.
Yes.
These two rights have been conferred upon you.
Conferred upon me. Now, my lord, your lordship will see. Here it says the lesser is the sole and absolutely seized and possessed, otherwise such and such of such and such. Then the lesser has in its own possession one room in the said building which is in occupation of the darbar. So this is not under the subject. The lesser has
You
agreed.
can get that.
Yes.
No difficulty on that.
Grant
You can
a
get
lease to the
possession of that, Mr. Bose. No difficulty on that.
Yes. No, well, that is not a part of the grant. Now, my lord, your lordship will see.
Oh, that Darwan's room, that is not part of the grant.
No, I don't think it is.
any portion of that property was under the physical possession of the lessor, Mr. Bose, or entirely tenanted.
Except the Darwan, entirely tenanted. And possession, in terms of this, possession was given to me. I am in possession. I am in physical possession of a substantial portion of the property.
Not at that relevant point of time.
Yeah, at the relevant point of
How could you? Because if it was tenanted, no,
no,
no.
other portions, not this portion.
I'm
Not the
asking you,
yes,
when the lease deed was executed,
yes,
your lessor,
yes.
did your lessor had exclusive physical possession, not constructive,
Understood, understood.
in respect of any portion of that property in 1979? Because it's admitted in the lease deed several tenancies, not
Yes,
one.
yes,
I'm asking you whether your lessor
yes.
was in actual physical possession of any portion of that property.
But I need to check on this and give your lordship a more constructive answer.
Because lease deed is silent, it says
Hmm.
several tenancies.
Hmm.
Because it does not clarify any portion physical possession or not, because we cannot now take into consideration anything on the basis of oral instruction.
Of course, of course. It just says subject to several existing tenancies in favor of various monthly tenants, but otherwise free from all encumbrance. The lessor
There
has
is no
in
other
its own
encumbrance
possession.
excepting tenancies.
Yes, yes, yes.
It appears, even if not the entirety, major or the maximum portion of that property was tenanted.
That it does.
It appears from the
Yes, yes, yes.
recitals of the lease deed.
Then, my lord,
Yes, Mr. Bose, you can proceed now.
then the lessee shall pay the owners and occupier share of tax. Then the
It
lessee,
is your obligation.
yes, my obligation under the lease. The lease shall
Basically, we
pay
are not
all
concerned with
enhanced.
that. Here we are concerned only your right so far as the tenancies.
No.
Your right is to collect rent and to file a suit for eviction
My lord,
as conferred by these lease deeds.
my lord, there's one very pertinent query that fell from your lordship. What was transferred by way of the lease? So, my lord, I'm trying to, my lord, get a logical answer for this. Now, if your lordship will see, first, what was given, what was my obligation, and what in fact was transferred by way of this lease. If your lordship will see, the letter doth hereby covenant with the lessee as follows: that the lessee paying the monthly rent, municipal rates and taxes, hereby reserved and observed, and performing terms, covenants herein contained on its part to be observed and performed, shall and will peacefully and quietly hold, possess, and enjoy the demised premises and every part thereof during the term hereby created, without any eviction, interruption, or disturbance from or by the lessor or any person or persons
There is no
claiming
meaning of
under
this
him
clause.
in trust of the lessor.
The question of your eviction does not arise if you are not in physical possession.
Well,
None
my
of
lord,
the clauses
my lord,
protects you.
my lord, that will take us to another, my lord, uh, gray area where, my lord, several proceedings are pending, and I am told that, my lord, where long-term leases have been granted
Because that
with
is
the
why,
right to sublet,
yes.
and the lessees have,
And what is the
by
lease rent
virtue of the
here quantified? Was the lease rent?
454.
200?
No, 454. Lease rent.
No, no.
Rent was 4,000.
No. I'm not saying of this property, suit property. Lease rent as per the which you have to pay.
Yes,
as per
that's what
this
I'm
lease
saying.
rent. 454.
I think it is,
4,000
I'll just,
lease and 6,000 in the second lease.
it is,
And my lord, my lord's query that whether Emerald was in possession of any part of the property.
Actual physical
My
possession.
lord, PW3 has said in his evidence, in the year 1979, Emerald executed a lease deed in favor of Koitan so and so with regard to the tenancy of the premises entirely.
hmm.
Entirely.
Entirely was tenanted.
No,
No,
the lease was given for the entire property.
this
That's,
was given.
yes, there's no doubt
My
about that.
query was whether Emerald was in actual physical possession, your lessor was in actual physical possession of any portion when lease deed in favor of Mr. Bose's client was executed. That was my query. Because if Mr. Chaturvedi, your argument is to be accepted, then there are two things. If maybe a portion was in actual physical possession, that could have been transferred to Mr. Bose by virtue of a deed. But if the entirety was in possession of the tenants, no portion could have been transferred for enjoyment. That for that I asked you.
Yes, so this says that it was entirely given, and then at that time, the next page, he says, after May 1979,
Yes.
no man of Emerald Company is there.
No, not after. My query was at the time of executing the lease by Emerald in favor of Khaitan, whether Emerald was in actual physical possession. Not after that. Because after that, it was leased out to Mr. Bose's client. So Emerald could not have been in possession. My query is prior to execution of this lease.
I look into it, not if there is anything.
Yes, Mr. Bose.
Yes, Manoj, now your lordship will consider clause 2. The lessor shall issue letter of atonement to the existing tenants for paying of monthly rent to the lessee herein, with effect from the first day of May 1979, and that the lessee shall be at liberty to sue all the existing tenants for arrears of rent or default as may be committed by them,
Please
or
read again this clause from the beginning.
the lessor shall issue letter of atonement to the existing tenants for payment of monthly rent to the lessee herein.
That means your client. So then you do not come within the exclusive definition of landlord under 2D. Because 2D rent collecting agent is for the owner. Here, letter of atonement, lease deed says rent is to be paid to you, meaning thereby you cannot be a landlord or the collecting agent of the owner.
Well, this is only the first sentence of that clause. If you allow me to place the entirety of the clause,
Pay
your
the
lordship,
rent.
I'm not a rent collector. If your lordship will see,
Yes, no, Mr. Bose, that is what I am saying. If you kindly come to the appeal court's judgment.
no, but kindly allow me to place this clause,
Yes,
then
yes.
I'll come.
Yes,
The lessor shall issue letters of atonement
yes.
to the existing tenants for payment of monthly rent to the lessee herein, with effect from such and such, and that the lessee shall be at liberty to sue all the existing tenants for the arrear of rent or default as may be committed by them or any one of them, and from the first day of such and such, and that similarly the lessee shall also be at liberty to initiate proceedings for eviction of all or any of the existing tenants by taking such legal action as may be deemed fit and proper, and the lessor shall assist and cooperate as and when required by the lessee. So this is the clause. So, my lord, the question is that, my lord, this clause, what right does this clause confer upon the lessee under this agreement? Would this clause, or could this clause be construed to be, or would this clause make me a landlord within the meaning of section 2D of the 56 Act?
Yes.
The inclusive definition of 2D.
Yes.
It says landlord 2D includes any person who, for the time being, is entitled to receive
Then
or, but for a special contract, would be entitled to receive, comma, the rent of any premises, whether or not on his own account. I squarely come within the
you are not
purview of
collecting.
landlord.
You are not collecting for the landlord. You are collecting on your own. This is the right given.
No, so that's what I'm saying, my lord. If your lordship, whether or not on his own account.
So now, Mr. Post, there are two things.
Yes.
What right? How can you collect? If the ownership right is not being transferred to you, you do not have a right to collect. Only the collecting right may be given. Then you have to collect, pay it to the lessor.
But there is no.
That's not the clause.
That's not the clause.
Clause says you have a right.
I have a right to collect, appropriate. So I have a right, my lord. I have a right to collect, appropriate, and enjoy the rent. Because there is no other clause in the lease which says otherwise, that you collect. So I am not an agent of the lessor.
You can collect on your own account.
I can collect, and collect for what? Collect to enjoy. So I am paying to them. So I collect and enjoy. The moment I collect and enjoy the rent, I squarely come within the definition of landlord under 2D. If your lordship will look at the language of 2D, it's an inclusive definition. Includes any person who, for the time being, is entitled to receive, or second situation, but for a special contract, comma, that is the second situation, would be entitled to receive, comma, the rent of any premises, comma, whether or not on his own account. So regardless of whether I receive it on my account or not, the moment I have the right to receive rent, I become a landlord. Of course,
own account.
So I am receiving it on my account. This agreement does not say that I am required to pay, say, 80% of 90% of what I collect to them, and the remaining I use it for other maintenance charges or anything else. Then I would have been a collecting agent, as you rightly pointed out. But in this contract, I am not. So they cannot deny the fact that I am a landlord.
They are denying.
No, of course they are denying. So I am disputing their denial.
Yes.
So the question is that whether I am the landlord or whether I come within the definition of 2D.
Yes.
Now, my lord, my respectful submission on this is, my lord, if I come within the purview of 2D, I have a right to initiate a proceeding under the 56 Act by issuing a notice under 13(6), which I did.
Show me the finding of both the courts below on this issue, how it has been held that you are a landlord.
All right. Lordship will take the compilation which was handed over by them.
The paper book.
Yeah, the
paper,
the shorter one, the thinner one. Thinner one. Well, the trial court judgment starts from the second page.
Yes.
Well, the issues your lordship will find at page 6.
Yes.
Then, my lord, kindly turn to page 7. Page 7 documents the 5 witnesses examined on behalf of the plaintiff, and then decisions with reason starts from page 8.
You can straight away come to page 9.
9. I'm at 9.
Second paragraph.
Yes,
In this,
these issues are common to each other and interlinked together. So these are taken up together for the sake of convenience and brevity of trial. In this case, Lana advocate for the defendant argued that there was no relationship between the plaintiff and defendant as landlord and tenant, as the lease deed has no validity at that. Page 7 begin, relevant point of time, learned advocate for the plaintiff submitted that the lease deeds were valid and there was relationship of landlord and tenant between the plaintiff and the defendant. I have gone through the materials as well as the evidence of DW1. He has stated that they used to pay rent to the plaintiff, Khaitan Consultants, since 1979. So I find that DW1 has admitted that the plaintiff is his landlord. It has been observed by the Honorable Court in 1996 to Calcutta Law Journal that payment of rent such and such in tenant is stopped from denying title of land.
Sir, from the head note, Mr. Bose. Law is otherwise. The quotation from the head note. Law is otherwise.
No, my lord, we will examine this, my lord. To what extent is the law otherwise, my lord? Kindly take this, my lord. It has also been
quotation from the head note.
It has also been observed by the Honorable Court, AR 93 Calcutta, that tenant depositing rent with the rent controller cannot subsequently agitate relationship of land.
Quotation from the head note. Because section 116 is very, very clear.
Yes.
Derivative title can be challenged.
Well, there is
you are not the inducting. You are not the inducting landlord.
No, I am the landlord who has been accepted by the tenant, who's now challenging my title. Now, to what extent can he challenge the title, and under what circumstances can he challenge the title? There is a Privy Council judgment, if I am not correct, 1912, which says.
If I am not correct, you are saying if I am not correct.
No. If I am correct, my lord, if I remember correctly, in 2012 there's a Privy Council which says that if you want to challenge the derivative, you have to hand over possession. You cannot remain in possession and challenge the title. But I'll pull that out. 1912. I think I should have it here.
The main thing, Mr. Bose, what is troubling is
I can understand.
With consultants.
I can understand.
Because there are so many division bench judgments. Only one went to the Supreme Court. Set aside on a technical ground. Yes, the effect of setting aside is the entirety.
Yes,
I'm not disputing for a moment. But that issue has been subsequently decided by many division bench judgments which have not been set aside.
There's one which has come, which is the one which has been placed before your lordship, the 2022 one.
2 or 3 more judgments, Mr. Chaturvedi has.
I will check them. I will see them.
By the same bench.
Okay.
But it's after all binding.
But unless my respectful submission would be, unless I can, the only way of persuading your lordship is that I have to show your lordship Supreme Court judgments which says otherwise. Yes. Well, there's a judgment which we always refer to in this concurrently thing, the Barabani Cole. Your lordship recollects Barabani Cole. Well, Barabani Cole does not find consideration by the division bench of Justice Bhaskar Bhattacharya. And there is one Anar Devi which has been referred to. Well, I'll show you, lordship. But then, my lord, it says, DW1 further stated that we do not admit plaintiff as our landlord. In this examination in chief in such and such, I further find that the statement of DW that he has admitted plaintiff as his landlord and his examination in such and such. So it proves that DW1 is trying to fill up the lacuna in examination in chief such and such, making the statement DW.
None of the.
But he did not.
Neither the trial court nor the appellate court took into consideration the effect of these lease. 105, section 54. These provisions were not considered.
Well, what is the, if it is for the defendant to argue this, the defendant makes a point. My lord, today the defendant says, if your lordship will see the argument of the defendant, my lord, why would the court call upon itself to decide the question what has been said? He just says that you are not my landlord. My lord, if your lordship will see, where is this been raised?
No, pleadings, it was taken, Mr. Bose.
Yes.
Mr. Chaturvedi, please show me that paragraph of your written statement wherein you have said that since it was in possession, he could not have been inducted, given his lease. Where is that?
Kindly. Let's see paragraph 14, 1-4.
Paragraph 14, yes, yes.
1-4.
Paragraph.
The last 6-7 lines. This defendant further states that the question of atonement only in case of absolute assignment by way of sale of an immovable property. My lord has got it very kindly.
Yes.
This defendant further states. I start with that any letter of atonement was served. Then I say that any such letter of atonement was served out, the same is not valid or binding upon this defendant without the consent, in as much as the letter of atonement is intended has the effect of converting the tenancy of the defendant from under the landlord defendant number 2 into a subtenancy. And then thereafter, immediately thereafter, I say this defendant further states that the question of atonement arises only in case of absolute assignment by way of
Also, this issue
section
was also not
54.
considered because Mr. Bose, the effect of your inducting as a lessee was in effect converting Mr. Chaturvedi's client to a sublessee. How could it be done?
With the
Can his status be changed without his concurrence?
the moment you pay rent, it is concurrence. You paid rent. You have paid rent
At
for
the time
11
of
years.
induction, at the time of induction.
No, I'm not.
He is not a party.
Yes.
He is not bound by those terms. So
But he's
can his
accepted
status-
those terms.
Mr. Bose, can his status be changed?
No, my lord, he's kindly see he's accepted those terms. His response is that he has received the notice. He has not objected to the notice. My lord, kindly see this.
Notice of atonement is
My lord,
denied.
kindly see
Notice
12A.
to quit is admitted.
No, notice to atonement is admitted. It's a question of fact, cannot be reappreciated now. Your lordship can see, can ascertain possibly the effect. But the question of fact, the concurrent finding of fact, which is at 12A, based on 12A. Kindly have a look at 12A of this page.
12A?
12A of the compilation of the, thicker compilation. This is a response given to my 13(6) eviction notice.
Yes. Oh, yes, we have received a notice about 15 to 20 years back that the Bangus, the owners of the above premises, had granted a lease thereof in your favor.
Then, my lord, kindly see a copy of the said lease was not delivered to us. We presume, however, the lease was. So, my lord,
Yes,
now.
what are the other decisions which you are trying to rely
No,
on?
my lord, now, no, not this. Now, my lord, kindly have a look at. Kindly take the, since your lordship is at that compilation, kindly have a look at the written statement once.
Yes.
And kindly come to page 20.
Yes.
That was in favor of Emerald. That is in favor of Emerald.
Bangur,
Bangur to Emerald. Where is the admission? Paragraph 14, I indicated no letter of atonement is served. Even if it is served, that is paragraph 14, my pleading. In written statement, I indicated it starts that letter of atonement.
Bangur's was the to Emerald.
Bangur to Emerald.
Bangur to Emerald?
Because he was inducted in 2023.
1923.
Yes.
No, what he's talking about is 1520. No, what he's talking about received of the notice of 15-20 years. He's not talking about this, not to Emerald. Emerald gave it to me. And Bangurs are Emerald. It is the company of the Bangurs. It is the company of the Bangurs. That's not what he said. If your lordship will see the language of the notice at 12A, we received the notice about 15 to 20 years back that the Bangurs, the owners of the first premises, had granted a lease thereof in your favor. Who is he answering it to? Khaitan, your favor means me?
Page 19A. Paragraph 2.
No, my lord, kindly, I'll come to that. My lord, kindly allow me to, my lord, suitably interpret 12A. He is writing this to me.
12.
Page 12A.
Page 12A.
Yes, my lord. So he's responding to the eviction notice given by Khaitan Consultants. So this letter is a response to kindly see the top, the addressee, Khaitan Consultant. Now, my lord, kindly read paragraph, the last para at page 12A. We received a notice about 15 to 20 years back
that the bangers, the owners of the premises, had granted a lease thereof in your favor. That means in my favor. It was granted in 79.
Yes, not in Emerald.
A copy of the said lease.
Your is Khaitan Consultant.
Then he's writing to me, he's writing to my eviction notice. A copy of the said lease was not delivered to us. Then he says, we presume, however, that the lease was for a specific period, thereby the right of reversion was reversed by the owners. Since receipt of the said notice, we have been paying rent to you as the lessee, authorized to collect the rent on behalf of the lessors. Now, my lord, on the behalf of the lessors comes in between, payable by the then tenants of the said premises. Such payment of rent does not mean nor can be interpreted as atonement. Of course, that is his interpretation of atonement. That's neither here nor there. Now, my lord, kindly come to page 20 of the, which is a part of the written statement.
20.
20.
Yes.
Now, my lord, towards the middle of the page, there is a statement. The plaintiff did not produce a copy of the lease to the defendant number 1. So they are the defendant number 1. Then the defendant number 1 has regularly paid the rent to the plaintiff until the month of October 1995. After the till the eviction.
That they have
Yes,
paid rent.
yes. Now under
Admitted.
yes. Then, my lord, apropos this, my lord, kindly have a look at what is his stand in the written statement. Then he refers to 2 recitals.
Yes.
My lord, kindly see. So he is conscious of the lease. He says he doesn't have a copy of the lease, but he's otherwise conscious of the lease. Be that as it may, my lord. Kindly take page 22, paragraph 6.
Yes. Yes.
He refers to my 79 lease. Then, my lord, he sets out a clause. Then, my lord, kindly turn to page 23, paragraph 7.
Yes.
Here he sets out the clause 2, which gives me the right to collect rent and initiate proceedings for eviction against the existing tenants. Then he says, paragraph 14.
Yes.
This defendant denies any letter of atonement was served, assuming but not admitting that any such letter of atonement was served upon the defendant. The same is not valid or binding upon this defendant without the consent of this defendant. Inasmuch as such letter of atonement is intended to and has been effect of converting the tenancy of this defendant under the landlord defendant number 2 into a subtenancy under the plaintiff, a mere lessee for a restricted term of 5 years, thereby depriving the defendant of its rights and privileges protected under the law of the land. Now, my lord, just pausing here for a moment. My lord, kindly see the letter of atonement once. Is it not here? I'll just hand over to your lordship of consideration exhibit 3 once.
Yes.
Now, kindly have a look at this letter of atonement. Just prepare a fresh copy of the whole thing.
Yes.
The term is specified. Everything is specified. The period tenure is specified.
What happened after 1989?
Extended. The period was extended
till
lifetime. It has still been extended. It still continues till date.
Yes. Who issues the letter of atonement? Mr. Bose. Who is the person authorized to issue a letter of atonement?
My lord, usually the person
Not
who
usually.
transfers.
I'm asking you.
No,
Who is
usually the
Because
person who
who has to
transfers.
accept? Who is giving? Person who has received, he cannot atone.
No, but even if he has
He
given.
cannot atone.
No, question
Because
is that.
talking of atonement.
Yes.
So that has been transferred.
Yes.
So the original lessor has not atoned.
No, even if they have not atoned. So that makes my situation even better. So I am writing to them saying that the original your landlord had atoned to me. So
It cannot be a letter of atonement
my lord,
in
even
true sense of the term.
no, my lord, even if it is not a letter of atonement, my lord, then now, so all the more reason they should not have accepted me as the landlord and not given me the rent.
That's yes, they have paid you rent, that is accepted.
So no.
What is the effect of that? That can be considered.
Correct.
But
correct,
whether
correct.
this is a letter of atonement,
No, I am saying that the stand that they take now at paragraph 14 of the written statement, that is not sustainable. They are not permissible in law to take such a stand. I'm saying such a stand is unsustainable. That's what I'm trying to
that I will
contend.
consider because
Yes,
the
of course,
effect
of course.
the effect of payment of rent pursuant to this letter to you.
Yes.
Whether they can now say that there is no landlord-tenant relationship between you and.
Correct. Correct.
Yes.
Correct.
Yes. What are the decisions we are trying to rely upon of the Supreme Court?
I will just make a compilation.
Yes. Give the references.
No, my lord, I cannot give it right now, my lord. Well, I make the compilation, but I may not.
Compilation will be given.
Of course, I
What
may
are the
not.
references?
I may not be requiring to refer to the few. My lord, based on my lord, your lordship's observation, which has fallen today, my lord, I'll accordingly prepare the compilation and give your lordship the relevant judgments. So,
how much time you will take, Mr. Bose?
Since now the onus has shifted to me, I will take some time.
How much time I'm asking you?
I will try and give me at least half a day.
Half a day.
Kindly give me Tuesday, second half, if of course convenient of the bench, subject to the convenience. Then I can prepare the compilation and come instead of wasting your lordship's time.
মঙ্গলবার কি আছে? Hard. Expectedly. Make a compilation of those judgments, the points, so that it can be concluded by 1:15.
But can we take back the list of exhibits? So we'll make copies and give it to your lordship.
Which one? This, yes. Please give
I'll
the
make
copies
copies.
of those list deeds. Also, please give a copy to Mr. Chaudhary.
I will do that. I'll do that. I'll do that. I'll do that. I'll do it. I'll do it.
Look at his face.
He has, but he will not share.
He's at your mercy.
But if Mr. Bose only indicates to my learned advocate and record the judgment he intends to rely, I can come prepared so that,
That he is keeping it close to his chest. He's
No,
not
my lord.
disclosing it.
Once I decide which are the ones then I'll give it to my learned friend as well. I will
So that,
try and share it by
Mr.
Monday.
Yes, that will better because he can come ready
Absolutely.
for the reply. It can be wrapped off on
Correct,
the
correct, correct, correct.
by
Will-
1:15. It can be concluded.
My lord.
Lordship will kindly don't put on timelines, man. We've got 3 months.
Timeline has to be because I
3
also have to.
months. Yeah, Lordship is quick. Lordship is very quick.
No, no, no.
My lord, we are aware of that, my lord.
No,
So,
no,
my lord, your
uh,
Lordship
3
wouldn't
months.
require 1.5 months to deliver a judgment in this matter. Any other matter, yes. Your Lordship will take 2 weeks, 3 weeks. So your Lordship will still have a month and a half.
I will not get to a month and a half. That's the difficulty.
No, even if we conclude, say if we take 1 more week between the two of us, so then your Lordship will
That time I
still
will
have,
not get. That is why.
why your Lordship has till the end of December. When is the judgment? 6th October, November, December, January.
December will be difficult for me. That is why.
Okay, okay.
Deeply obliged. my lord.
That is why I'm only getting this November.
Okay.
That is why keeping that timeline in frame in my mind. Only for that.
No, Josh, I have no personal difficulty. So, very well.